Huh?
Is the
Yes.
matter on my list?
No, my lord, it's
No,
the inclusion.
no.
Okay.
My lord, for correction, my lord.
Hearing.
Correction. Instead of Chonditala police station, it was written Singur police station in paragraph number 5. Correction for correction.
Inclusion for hearing.
No inclusion. To be mentioned. Just write which police station you want.
Which police
Just
station?
make the correction.
Properly এটা ই করে দিন আমরা পুলিশ স্টেশন হ্যাঁ কোন সা পুলিশ স্টেশন পেন্সিল দাও
Call out the list.
Item number 1, I am for the petition. This is my 2 affidavit in reply in connection with the affidavit filed by the private respondent as well as the private respondent.
Yes.
And your lordship kindly takes up my affidavit. My affidavit affirmed on in terms of your lordship's order. First, I will to satisfy 20th December 2024. Your lordship was pleased to direct me to affirm an affidavit to avert the submission made on behalf of the municipal authority with regard to my bona fideness. Have you also got it, my lord?
Yes. Just a minute.
Yes, as well.
না লিখে দিই পরে
Yes. After my order, you had filed an.
Yes, man. I have filed the affidavit.
Just a
I
minute.
tried to satisfy. I will try to satisfy your lordship. The allegation which has been raised against my client are all false, fabricated, with malafide intention.
Yes.
They have questioned my bona fide. I will now try to show your lordship. First of all, lordship, kindly come to the.
My lord, sorry for indulgence, my lord. Before my learned junior friend starts, my lord, is making some issue, my lord. If your lordship takes trouble to go through your lordship's order passed on 1st October 2024.
I was just reading that.
My lord.
Yes.
May I start?
Yes. বলো সেটা বলো কোটে বলো
But paragraph, you will also kindly come to page 17 first. First, you will also kindly come to page.
I'm sorry to butt my learned friend, my lord. I have been briefed in this matter, my lord, just day before yesterday.
So
I haven't got the entire brief.
you have been
Yes,
briefed,
sir.
but you don't have the brief.
My lord, not in entirety. I'm sorry to say this, my
You
lord.
appear for whom?
My lord, for the private respondent.
Private respondent.
Mr. Bhattacharya used to appear.
Yes.
Now, my lord,
He used to appear on behalf of the private respondent in that.
You're a
event.
senior advocate.
uh,
Recently
My-
designated. Where's your briefing counsel?
Briefing counsel.
How can you appear without a briefing counsel? Sir, is this a practice here?
No, 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 not at all. এই দাদা কই?
Where's your briefing counsel, sir? If this is the practice that the senior advocates appear in this court without a junior, then I am really surprised.
I thought Mr. Sinha is here. Now, my lord, Mr. Sinha is.
So you should sit down, I think.
Yes, my lord. I do not have right of audience, my lord.
Till the time you don't have a briefing
Yes.
counsel, I think you should not appear.
Yes,
Propriety
yes,
demands
certainly. my
that you
lord.
should
There
not
is no doubt about it. Well, I thought Mr. Sinha has entered.
Mr. Sinha has not entered, unfortunately.
I'm
Yes.
sorry. I'm sorry to butt, my lord.
My dear, also can go to page 17 first. What is this one? This is the certificate, residential certificate issued by the Midnapur municipality, chairman at the signature of the chairperson, authorized signatory, where I am residing. Have you also got it, my lord?
This is para 4.
Yes, ma'am. You will also be stating the paragraph 4.
Your para 4 of the affidavit. Where
Yes,
have you stated?
my paragraph 4,
Yes.
and that is
This
page
address is
17. Annexure is page 17. That is a certificate
Residential certificate issued by
by the Midnapur municipality. Question was raised that I am not resident of Kolkata. Yes, I was a resident. I intend to purchase the flat. That's why.
পেয়ে যাচ্ছি ওটা।
the first writ petition which you had filed, the order was passed. You have annexed the order,
Yes, but I have annexed the order
page 24.
24. And I will come to that. The writ petition, how many writ petitions I have filed? I have filed only
So
3 writ.
in that case, you wanted to buy an apartment in a different building.
I
Now you
went.
want to buy a different building.
I want to buy only one building.
So you keep going to apartments.
3.
I can show you lordship is more than that, my lord. It's not.
Yes.
And I have filed only 3 writ petitions. That is WPA number 11584 of 2021, WPA number 12443 of 2023, 11584 of 2021,
Yes.
WPA number 13672 of 2023,
Yes.
and 9762 of 2021, which is present before your lordship. Which is before your lordship.
So the first one you had filed for Shubhrale apartment.
Subhralaya apartment,
Same Midnapur.
municipality.
The second one,
Second one is also against the Midnapur municipality.
which for some apartment again.
Against some another apartment.
Which apartment? Which apartment, sir?
Just a second. Obhishek apartment.
Your representation
Which one, my lord?
was decided in mat number 901 of
Yes, madam.
2001.
My lord, I'm coming to that. So for 11584 of 2021, that was disposed of by an order dated 5th August 2021. I'm coming to that, my lord. I'll show to that.
No, just a minute. Just answer this question.
Yes, my lord.
Your representation in that mat number 901 of 2021
Was
disposed of?
disposed of. The municipality authority found there is a illegal construction.
All right.
And since I was not satisfied with the order, I filed another writ petition challenging that order. This is a continuing one, which is pending before the Honorable Justice Ananya Bandyopadhyay. That is at page 34. They have issued the demolition order considering my representation in terms of the order of the Honorable Division Bench.
Yes.
Alright. Initially 11584 of 2021,
Yes.
order was passed. Dispose of the writ petition on 5th August 2021.
Yes.
My client was not satisfied, preferred an appeal, being MAT number 901 of 2021.
Yes.
Appeal court directed the petitioner to appear personally. He appeared, and ultimately order of demolition has been passed.
Yes.
My all-through challenge was that not only the demolition unauthorized construction, but in that writ petition, but the plan was sanctioned illegally. I filed a writ petition, which is pending before your lordship. That is WPA number 12443 of 2023. Another writ petition is that 9762, which is before your lordship. So far, that writ petition which is pending before the Honorable Justice Ananya Bandyopadhyay, that is with regard to Submersible apartment. So far, pending before your lordship, that is 9762 of 2021. This is the another one. This is with regard to, just a second, when I am giving the name. Java construction.
Yes.
And another is that 13672 of 2023, that is against the Abhishek apartment. These are the three writ petitions I have filed.
For Abhishek apartment, there's no order which has you.
Till today, it is pending before the Honorable Justice Supratim Bhattacharya. I have annexed the order sheet also. Only these three writ petitions I have filed. And what happened, my lord?
Yes.
So far, the writ petition pending before the Honorable Justice Supratim Bhattacharya. In that writ petition also, order has been passed for measurement of the building. And in that case also, they have found there is illegal construction.
Yes.
Now, my lord, your lordship, kindly come to my affidavit now. What I have stated.
Yes.
Prior to that, may I show to your lordship that they have addressed to me that I am residing at the Midnapur municipality? They have
No, I've seen that. Page 17. you
no, page 70 is the certificate. Next, page 18 is my ration card.
Yes.
Next, your lordship, kindly page 19.
Yes.
Who has issued the letter for hearing?
Yes.
That Dipanjan Datta, before your lordship,
Yes.
address issued by the chairman, office of the Midnapur Municipal Councillor, Midnapur Municipality.
All right.
Next page, my lord, I have participated in the address is the notice, page 20. Have your lordship got the address?
Yeah.
Next page also, they have issued another letter. This is the envelope. Letter is next one. Address.
Yes.
Next page is the notice. But being a citizen of a petitioner before your lordship is an intending purchaser. He went to purchase a flat in the Midnapur municipality and he went to 3 apartments. And in all 3 apartments, they have found the illegality.
Yes. Yes.
My question is that I'm putting this question to myself, whether the citizen of India has the right to address the honorable court when there's an illegality committed by the statutory authority or not. And your lordship I will show to your lordship in this writ petition also that the Midnapur municipality issued 410 sanction plan with post facto approval. And first of one is this one. Now your lordship kindly come to my annexure, page 38 once. Had the petitioner has the sufficient fund, I would have instruct the petitioner to file 410 writ petition before your lordship. Page 38, your lordship, kindly come to page 38
Of your
once.
affidavit.
Of this affidavit.
Yes.
May I read, my lord?
Yes.
Minutes of the proceedings and general meeting of the Board of Council of Midnapur Municipality held on 19th September 2024. Have you also got it, my lord? At the top, page 38.
Yes.
Members, I am not reading that. Resolution 1. I am not reading the resolution 1. You will also kindly come to the next page, page 39. Resolution number 6. May I read, my lord? Regarding granting permission against the plan of high-rise building in Midnapur municipality area. Mohammad Soifullah, Honorable Councillor, Ward number 21, Midnapur municipality stated he has submitted a letter on 8th April 2024 before the chairman, Midnapur municipality, complaint against the issue of illegal permission of high-rise building plan, but no fruitful reply has yet been received from him by him. He claimed this should be followed properly for granting permission of building plan. Dr. Golok Bihari Maji, Honorable Councillor, Ward number 6, Midnapur municipality, stated that as per sanctioned building plan, the owner of the building did not follow the building rule plan during construction of the building. Accordingly, there should properly supervised by the SAE during the construction of the building, whether there is a properly constructed or not. Next page, ma'am.
Yes.
Next page, page 40. Regarding sanction of high-rise building plans, till date, Honorable Chairman has approached before this House that all pending high-rise building plans shall be approved. In future, not a single high-rise building will be sanctioned without following the West Bengal building rules. But this is the post facto approval. Building has been raised approval subsequently. Now, let's kindly come. Now, kindly come to resolution of number 12. Regarding approval of 410 numbers of building plan from 8/4/2021 to 31st March 2023. Assistant of Plan Department placed one list of building plan of total 410 numbers of for a period of 8/4/2021 to 31st March 2023 for approval. Discussed elaborately and all plans are approved by this house. The list of plan enclosed herewith.
Yes.
So kindly come to the page 43 now.
Yes.
Plan number and date. You will also kindly note that plan number and date. Have you also got it, Manoj?
Yes.
Dated 8th April 2021. This is the subject matter before your lordship. Subject building in which plan has been sanctioned. Allegedly. Name of the I am not on that. When it has been approved, my lord? 19th. 19th September 2024. Plan of 2021. Is it not the malafide intention? Is it the malafide intention of the petitioner to bring the illegality before the honorable court? I am putting this question to myself, my lord. Whether the statutory authority has any right to see
Yes.
whether the statutory authority will act divorcing the statute. Is it the malafide intention of the petitioner? If I point out any illegality in the Midnapur municipality, that is the malafide intention. And more surprisingly is that, my lord, in all the writ petitions which I have filed in 3, except this one, in all the writ petitions, they have passed an order of demolition of the building. Had I the malafide intention, there should not have been had the municipality did not have committed any wrong, or the private respondent did not have committed any wrong, there should not have been any demolition order.
Yes. Yes.
Let's kindly come to page 13 once more. Resolution number 6, once more. Why I am repeating before your lordship? May I read once, my lord, for my satisfaction?
Yes.
Regarding granting of permission against the plan of high-rise building in the Midnapur municipality area. Mr. Soifullah, Honorable Council, Ward number 21, Midnapur municipality, stated he has submitted the letter date such and such. I am not reading the same. I am subsequently another chair councillor. I am not reading this one. You also kindly come to page 40. Regarding sanction of high-rise building plan till date, Honorable Chairperson has approached before the House that all pending high-rise building plan shall have to be approved. Why? If they have committed illegality, you have the power to demolish the same. Why approve? And thereafter, in future, not a single high-rise building will be sanctioned. I am putting this question to myself. Why? They will sanction. They have to give the post facto approval instead of demolishing. Instead of Cancelling the same?
Or-
Are the municipal authority hand in gloves in with the private respondents? Why, my lord, I am saying, your lordship, now kindly come to the writ petition. Your lordship, kindly straightway come to my page 31, that is my complaint.
Yes.
It is dated, your lordship, find the date at page 37, dated 8 January 2021.
Yes.
Your lordship, kindly come to the page 41. Who has issued the same?
Page 40.
40. After my complaint, may I read, my lord, once? Subject: hearing and stop of your lordship, can note the date first. 25th January 2021.
Yes.
Hearing and stop the extension of floor of RS plot number such and such. It is alleged the administration against you that constructional work of building B plus G plus 11 is being done by you on the above plot of land, contravention of West Bengal Municipal Act and rules, WBM, that is West Bengal Municipal Act and rules. You are therefore directed to stop extension of floor on receipt of this letter, failing which legal action will be taken against as per law. And what is their admission in this letter? The private respondent has constructed B plus G plus 4 building. That is their contention, that is their letter, that is their admission. It is dated 25th January 2021. Have your lordship got it, my lord? On the basis of my letter, complaint. Now, your lordship, kindly come to their sanction plan, which they have annexed with their opposition. When the plan was sanctioned, the lordship will be astonished. Before plan was sanctioned, building has been raised. This is letter dated 25th January 2021. And the building plan was sanctioned by the signature of the chairman on 12th April 2021.
Yes.
And you'll also kindly come to the plan once. There is no sanction plan, admittedly. They have got the plan. May I read only one thing? So kindly see, may be approved. It is sub-assistant engineer dated 12th April 2021. As per order of the chairperson dated 7/1/2021. May be approved and said that has been approved in the year 2024.
Yes.
To also be find astonishing that the plan was submitted for sanction 8/4/2021, whereas the notice says we have already raised B plus C plus 11.
Yes.
I have the malafide intention according to my landed friend.
Done.
Now, subsequent plan, you'll also kindly see this plan. They have sanctioned initially B plus C plus 3, subsequently 5th to 8 crore, 5th to 11. Your Lordship, they have said that for raising this building, we have to keep all these spaces in both all four sides. Your Lordship, may I request your Lordship kindly appoint a special officer to see whether this space has been left open or not. If left open, I will be out of court. Kindly appoint a special officer at my cost. This space has been left open or not. Kindly appoint a special officer. If it is being left open, I will be out of court. You will also impose cost accordingly.
What else?
According to my law, Municipal Act, before a plan is being sanctioned, site plan has to be sanctioned prior to the sanction plan, or the person who is want to sanction his plan can submit his site plan and the building plan simultaneously, and the municipality will sanction the site plan first, thereafter the building plan. In this case, my lord, what happened? Site plan has been sanctioned later on before the plan has been sanctioned. May I show to that? So for the judgment, may I decide on, or your lordship decide the?
No need. Yes.
My lord, again, I will be taking the point of maintainability of this writ petition. This writ petition was filed with malafide intention, absolute malafide. Though my learned junior friend has demonstrated before lordship that he has filed, his client has filed only 3 writ petitions, but so far the record is concerned maintained by our High Court, there are 4 writ petitions. My lord, I made reply to his affidavit. Your lordship will find paragraph number 6. I will take my lord kindly takes travel to take the affidavit in opposition on behalf of the respondent 1 to 5 against the affidavit prepared by the petitioner.
Your main affidavit in opposition or?
No. They, recently, in terms of your lordship's order, my lord.
Yes. Yes.
Firstly, my lord, my learned junior friend has shown your lordship that one that is page 7, annexure R, with his affidavit, allegedly a certificate. And in reply to his submission, my lord, I made in page number 3 of my affidavit that writ petitioner of his affidavit has tried to demonstrable court purpose for ulterior motive that he is a person of Midnapur. The copy of the certificate annexed to the said affidavit allegedly issued by the Midnapur municipality is not a certificate issued from our office. If the same would have issued by Midnapur municipality, there would have been a memo number and countersign of concerned departmental clerk in said certificate. My lord will find that no number is there and no countersign is also there. In my lord, petitioner was trying to, my lord, submit that municipality issued so many letters from the evidence from the envelopes, annexed envelopes, but fact remains this petitioner never ever attended any hearing held before the Midnapur municipality. Only once 1 month before, regarding one matter, he went to a spot for verification. Never ever he attended in any hearing. My lord, my affidavit, my lord, 6D, though petitioner has annexed a few envelopes containing the address of the petitioner used by the Midnapur municipality or of the Midnapur, and allegedly the petitioner has received the same, but fact remains, never ever the letters was received by him personally. Those were received by others. He is an implanted person, my lord. He is an inhabitant of Kolkata, Boranagar, Kolkata. He is not at all resident of Midnapur town. Moreover, my lord, I have demonstrated in F, 6F in my affidavit. There are 4 writ petitions. All the writ petitions, petitioner says he is an intending purchaser. And last occasion, my lord, I tried my level best, my lord, to make my submission that petitioner wants to purchase in every locality in Midnapur town. That is his ground of aggrievance. Your lordship knows better than me that petitioner has to show his infringement of his personal existing right, existing personal right. Then only he can to be said that he personally aggrieved. He is not only a personally aggrieved person. He has no right to sue. He cannot come before this court with his malafide intention. Your lordship will appreciate that writ court cannot be used as the money earning tool. And my lord, sometimes I appear on behalf of different petitioners in different courts of this honorable court. And persons like this type of blackmailers, they are filing repeated writ petitions and going to the private respondent, house of the private respondent, and claiming money. Give me money, then I lose the petition. And it has happened. In before Justice Kaushik Chandra, my lord, one matter was moving relating to Bali municipality, my lord. A person filed 12 writ petitions. I can produce that copy of the list, my lord. Very unfortunate. And out of 12, my lord, 12 criminal cases were lodged. 8 cases, my lord, charge sheet submitted.
What argument is
My lord. Even my lord has allowed my learned junior friend, my lord, which is
sensible argument?
my lord,
Don't
which
talk
is
about some cases which has no relevance to this.
my lord, some irrelevant
Have you
papers have
filed
been
a-
annexed.
You are appearing for the municipality.
My lord.
You are saying that the certificate which has been issued by him is a forged certificate.
Oh, my lord,
Wait a minute.
says non.
Wait a minute, sir.
My lord.
Have you lodged an FIR? Have you lodged an FIR?
My lord, it has come to our knowledge from this affidavit.
Have you lodged an FIR after this? It has come to your knowledge now.
That I have to take instruction, my lord.
What do you mean take instruction? I know you have done nothing. Next. Don't make frivolous arguments. Yes.
If my lord petitioner cannot prove infringement of his existing personal legal right, it cannot be said that is personally agreed. My lord, paragraph number 6F, my lord, of my affidavit.
Yes.
Paragraph number 3 of WPA number 13672/2023. Paragraph number 3 of WPA 12443 of 2023.
Yes.
Paragraph number 4 of WPA number 11584 of 2021 and WPA number 9762, which is pending before your lordship. My lord, he says that he is a permanent resident of Baranagar, Kolkata, and intending purchaser of flats. On the last occasion, my lord, I had handed over one judgment of Bombay High Court, subsequently travel up to Supreme Court.
Yes.
And in Bombay High Court, while Justice Dipango Datta, the Chief Justice, my lord, like this case, petitioner was repeatedly filing several cases against the promoters and builders of Mumbai. Ultimately, petition was dismissed and rupees 1 lakh cost was imposed. Thereafter, it was traveled to Supreme Court and it was also dismissed.
Yes.
And my lord, regarding the existing was the personally aggrieved, my lord, I will hand over your lordship 8 judgments, my lord, passed by Honorable Supreme Court. That I will make a compilation and I will hand over to your lordship.
Where's the compilation? Hand it over. When will you do it?
Within 2-3 days, my lord.
I will keeping it reserved that you'll give it after 2-3 days. You're
Then
making
I can
argument.
citation herein now, but otherwise, my lord, I can hand over, my
citation
lord,
will
only
do.
the copy of the judgment.
Is this the way to address the court?
My lord,
Is this the way to address the court?
actually, my lord, on the last
Is this the way
my
to
lord,
address the court?
kindly hear me, my lord. last occasion I mentioned, my lord, I am suffering in a big problem. I have lost vision of my left eye.
Why
My lord, I cannot
why
see-
don't you take time? Did I ask you? Did I compel you to argue the matter?
No.
Did I compel you?
Not.
Did you say that I am suffering from
My lord,
some
my lord,
problem?
I am handing over the copy of the judgments, my lord, passed by Supreme Court.
Give
I
me the
am-
copies right now.
What? I can have.
Argue the cases on the base of the material. And if you are not prepared, seek time. Seek time. Don't make these kind of frivolous arguments here. I'll give it after 2 days. I'll give it after 3 days. Is this a way to handle the court?
Sorry, my lord. Just I am handing over.
What kind of submissions are these? Unique ways of submission.
আমি সাইটেশন আগের দিন দিয়েছি দিয়েছি
Learned counsel for the petition respondent corporation seeks time to file his written submissions. Both the parties are directed to file their written submissions within a period of how much time you want?
1 week?
1 week? Within 1 week. With advance copy to each other.
I will hand over a copy, advance copy to him. He will do it.
Put everything in your written submission. Don't do a piecemeal job. Whatever your submissions are, record it.
Fine.
All judgments you want to rely, put it in there
Fine.
with annexures.
Fine.
Don't have this habit of arguing things from here and there.
Fine.
You are?
My lord, before my lord takes up the next matter, may I humbly seek leave to file an application? We have prepared it today, for which
Are you mentioning something?
seeking leave to file an application. I seek apology, my lord. I know
Please
this
do
is not the
not.
right time.
Do not even try it. Don't. Next.
My lord, may I then come back at 1:15
When is the mentioning done? 10:30 in the morning.
in the morning?
Come tomorrow. Next.
And within 7 days, I will file my report. Which,
Give a date in this matter.
3rd April.
30, my lord, I am appearing for the petitioner, State Electricity Distribution Company Limited, to file a report regarding the occupation of my land there.
Well, I am for the WBSDCL, my lord. Report is
Yes.
ready, my lord. My lord, the brief, the clerk is not here, my lord. My lord. May I pray for password?
Mr. Devanjan Mukherjee appearing in
he
this
is.
matter, he was here right now, but
Yes.
now I can see him. He was there.
Report is ready, my lord. Can it,
Okay, we'll have it tomorrow, not today.
much.
My lord, kindly pass it over.
No, tomorrow.
My lord, I am for the petition. My lord, this is a
Distribution company. yes.
new electric connection of submersible pump set, my lord.
Yes.
I have made application on 18 June 2024.
Yes.
And
Two
till date,
speed
my lord,
post.
connection has not been, even my lord, quotation has
My
not
lord,
been issued.
Mr. Mukherjee has-
Two speed posts, he has
We'll have it
sent
tomorrow, Mr. Mukherjee. You have the report?
Well, only 5 minutes it will take.
We will come at 12. Come at 12.
12.
I have complied everything, my lord.
Yes, madam. What are your
My lord,
instructions?
Yes,
acting,
Lordship, when he has filed this petition, he has not complied anything. Subsequently, he told that he has complied anything. I will have to take instruction.
Take instruction.
I'm grateful, Lordship.
You decide the representation. You had made a representation. His application, decide his application.
No, no,
has not.
no.
You, madam, decide the application of the
Yes, yes,
petitioner.
yes, yes. Yes. Sorry, I'm sorry.
Take down. The petition is aggrieved by non-grant of electricity connection by the respondent authorities for carrying out his agricultural activities. Non-grant of electricity connection to his submersible pump.
Submersible pump.
To his submersible pump. It is the case of the petitioner that he is the owner of plot number 196, jail number 125, Uttar Mahinagar under Gazol Police Station, District Malda. Full stop. Petitioner states that he had installed the submersible pump at his plot and had applied for an electricity connection for the same on, when did you apply?
My lord, 18 June 2024.
18 June 2024. Full stop.
Speed post.
Have you made the payment? Quotation amount? No.
No, my lord.
On 18
Yes,
June.
ma'am.
Despite regular follow-ups, the respondent authorities have failed to take any steps to grant electricity connection to the petitioner. Being aggrieved by such inaction, the respondent has preferred the present writ petition. Full stop. Learned counsel for the respondent authority submits that they are ready and willing to decide petitioner's application for grant of new electricity connection within a period of 2 weeks.
If
It
he
is-
complies the formalities, Lordship, I don't know.
Yes, yes.
Yes, madam, yes. It is the statement, in view of the statement made by the learned counsel for the respondent, this court deems it appropriate to dispose of the present writ petition, directing the respondent authority to decide petitioner's application for grant of new electricity connection within a period of 2 weeks. The electricity connection shall be granted to the petitioner only after compliance of all necessary, after due compliance of all necessary requirements. Full stop. With the above direction, the present writ petition is disposed of.
My lord, direct him to issue quotation, my lord.
They'll do all necessary compliances.
Yes,
I'm great.
yes, I'm grateful, Lordship.
Affidavit of service taken on record.
Grateful, Lordship.
Yes.
35.
I'm for the petition, Lordship. 35, I'm for the petition.
Yes. Yes.
My lord, for the learned counsel for CAC, Miss Srimoy Mitro is on legs. My lord, may kindly keep it on Tuesday.
Tuesday, Lordship.
Tuesday.
Moving on. 37.
My lord, I am for the petition.
Well, I'm for WBCD.
No, this is a new electric, the same as 31, my lord.
Why?
I have made application, my lord. He has not issued quotation, my lord. I have complied all formalities, my lord.
This is a different one.
Application, my
It's
lord.
not submersible pump. This is electricity
This-
connection.
This is a submersible pump,
Submersible pump.
My new electric connection.
My lord, my instruction was, my lord, there was no submersible pump installed, my lord, no earthing complete, no wiring complete. My lord, he short
How
time.
many petitioners?
My lord, one petition.
My lord, two petitioners, one
ear-
petitioner has
earlier-
withdrawn
Earlier,
on the last occasion.
my lord, he is misleading, my lord. My lord, I have take photo, my lord. This is my submersible pump set, my lord.
This was my instruction. He short time, my lord,
Not, my lord.
to my lord,
Earlier,
take
my lord.
instruction. Now he is submitting that
Always
everything
he
is
is
complete.
misleading before your lordship. I have taken
Why
photo, my lord.
misleading? This is my
And, my lord,
instruction, my
appoint
lord.
a special officer, my lord, in my cost.
See, the problem is
I honestly submit, my lord.
he doesn't make misleading statements. It's a department which briefs him.
My lord, not him. my lord.
As per my written instruction, my lord, I'm submitting.
Not his office, I'm sorry.
You decide his application.
Very well, madam. মানে if it is installed, my lord, we will, মানে if he completes all the formalities, my lord,
Submit. আবার দেখাচ্ছি ছবি তারপর
হ্যাঁ তো আমি কি করে দেখব? আমি দেখে তো কোনো লাভ নেই।
তাহলে স্পেশাল অফিসে নিয়ে করে আমার কষ্ট
পড়াও না, আমাকেই পাঠাও।
He has already made all the relevant things. Why you are not giving? Huh?
My lord, subject to correction, my lord, maybe, my lord, after the last date, my lord, it has been done, and now, my lord, he has come up with this.
No, it looks like new. It looks like new. It doesn't look old at all.
Yes.
Please have a look at the picture.
Yes.
This looks
I'm
new.
not going.
Subsequently, Malad, he raised objection before.
This looks absolutely newly painted.
On
Look
13,
at the
my lord.
paint.
I have made application, Malad, 23rd October.
বাবা এইটা পরে করেছো 13
Talking about the picture.
last order was passed on 13. Now we are on 27.
Already I have complied, my lord.
So you have
Enough
complied.
time, my lord.
After this, you have complied with. So now the submersible pump has been put on site.
My lord, kindly record, my lord, this was my instruction that those who are not, my lord, complete. Now, my lord, he has come up with the instruction and, my lord, photograph that everything has been completed. My lord, if he has completed all the formalities, my lord, we will give collection with a certain time.
Learned counsel for the respondent. No, but you should have taken better instruction. You take better instruction, sir. We'll have it after 2 days.
My lord.
You take better instruction.
Very well.
You take better instruction. We'll have it after 2 days. We'll have it on Tuesday.
My lord, kindly passes an order, my lord, 2 days, my lord.
If I pass an order, it will be against you. This case you do.
No, my lord, for the,
you
my lord, kindly pass an order for further inspection. My lord, we will
Why
inspect.
should I pass an order for further inspection?
Very well, my lord, we will come up with, my lord.
You come up with the.
Last
He has already shown you the pictures. You tell your officer now. This is your responsibility.
Very well, my lord. Let me get a copy of this. I have a copy.
Last occasion he took time 13th March, my lord.
আরে আমি নিইনি টাইম ভালো করে পড়ো কি উল্টো
Just give him a copy of the picture.
My lord.
You took time.
All right. Tuesday.
No, my lord, 3rd or 4th. There is a Eid.
Third.
Yes.
My lord,
Great.
with respect
Okay.
to item number 35, I was just rushing down. He's here, my lord, the petitioners.
We'll have it later, man.
Tuesday.
Item number 40.
Well, I'm for WBC.
Lordship, I'm for the petitioner. Lordship, the last occasion, Lordship, leave the insert the name of the private respondent. Lordship, allow the insert the name of private respondent and file the supplementary affidavit. Lordship.
Yeah, made the private respondent a party.
Applicant, Lordship, the made the application.
Yes,
My lord,
what are your instructions?
my lord, my instruction is, my lord, he made online applications. My lord, the system is, my lord, after making online application, my lord, he has to submit, the customer has to submit, my lord, the hard copies of those the applications. My lord, the petitioner didn't submit it. And my lord, he has failed to, my lord, show any, my lord, authenticated document of occupancy of the flat. He is only showing, my lord, on the your lordship kindly remembers, my lord, on the last occasion, he has annexed a possession certificate issued by his promoter. My lord, Apart from that document, my lord, there is no document showing his occupancy of the flat. And my lord, the deed has also not been registered by the promoter in his name, the sale deed in respect of the flat. That is also in this. But that is the difficulty we couldn't, my lord.
You have approached the consumer court also.
Yes.
Consumer court is pending, lordship.
So how come you have come here?
Lordship, he is possessed the flat, lordship. He
But
made
for the same cause of action, how have
No,
you
no.
filed this writ petition?
on the non-availability or not the registered deed, he filed the consumer court, lordship.
What has he filed for in consumer court? Is he seeking LCD connection also in the consumer court?
No, seeking here, lordship, the only not registered.
What has he filed in the consumer court, madam?
Filed the consumer court, lordship. The last time, lordship, see the annexer.
I can see the annexure.
Annex filed 2024, lordship.
Annexure will not show what is the plea which you have taken before.
Yes, lordship, page number 16, CC case number 164 of 24, lordship.
In your additional affidavit, you have put this, right?
And annexer the lordship, the original deed petition, lordship.
Page number?
Page number 16.
My lord, kindly come to page 20 of the.
Where's the affidavit of service?
It's hard, lordship, not application not ready, lordship.
Sorry?
Affidavit service not ready, lordship.
You should have said this the first thing. Learned counsel for the petitioner seeks time to serve upon the private respondent. Let this matter be listed after 2 weeks.
ওই ফাইলটা দেবেন ওই এই ফাইলটা দেবেন ওই যে নামগুলো ইনসার্ট করতে বলেছিল করবে
10th April.
There's a dispute going on. First, they were granted a commercial shop that was not given to them. Then they were given this flat. Then subsequently, the flat has also changed to a different property number. So till the time that clarity is there, nothing can be done.
Here here situation is better. In some cases, the promoter has taken money, didn't register the deed of sale, and has.
Here also, you're not registered.
No, not even applied for the common meter connection, which is his obligation to apply and get it before leaving. The promoters, he has fled everyone. Great.
Item number 43.
I am for the petition, my lord.
I am for the response.
I have served the copy to all parties, my lord. In this case, my lord, the West Bengal's agency report, my lord, came for inspection without giving any notice. And my lord, your lordship kindly turn, my lord, the first annexure, my lord, annexure, page 23, first annexure, page 23.
আমারটাতে তো কোনো পেজিনেট করা নেই।
এটা তো ওটা কি হবে?
হ্যাঁ, ব্রিফে কোনো পেজিনেট নেই তো।
Page 23, annexure P1.
পেজিনেট করা নেই।
Yes.
Then, my lord, they file a FIR, my lord, then page 24, under section, my lord, 135 of Electricity Act, page 24. Next page. Now, what has happened, my lord? After FIR, my lord, I do not know, because everything was done behind my back, no issue, notice was issued before inspection, my lord. What has happened, my lord? Then I made a prayer before the authority, my lord. The objection, made a raise objection against the illegal thefting. Then what has happened, my lord? They issued a notice to me, my lord, page 32.
So there's the provisional assessment. Did you file your objection?
Yes, yes.
They have filed a final order?
Yes, after filing the objection, my lord, they issued this notice, my lord, your lordship, kindly see, my lord. Page, final assessment, that is a page, my lord, 26, annexure P5. Here, my lord, it is decreased, my lord.
Final assessment has already made.
Final assessment, my lord.
Your page numbering is wrong. Where is the final assessment order?
That is a page, my lord, 26,
My lord,
annexure P5, my lord.
in
Yes,
my-
my lord, from 18 lakhs to 15 lakhs.
Well, in my brief, there is no pagination, but it is annexure P5.
Page 35.
P5,
It's page
annexure
35.
Page 35.
It's 35. এই প্যাজিনেট করেনি কিছু না।
Page 35, sir.
Yes, page 35.
কোথায়?
So you challenge it.
But, my lord, in this case, my lord, what has happened, my lord, the division bench passed an order, please you pay 50%.
That is for anticipatory bail.
50%, my lord, I have deposited 50%, my lord.
That's good.
Unless, I have deposited 50%, my lord. Unless, my lord, I am not proved guilty, my lord, then what has happened, my lord, they have done everything behind my back. Even, my lord, your lordship, can you see last time, my lord, I wanted the details, my lord, they have not supplied the same. Your
File
lordship,
RTI.
and
এটা কি 36 কি আছে?
last annexion, my lord, that is page, because, my lord, 26, my lord, it is, page 2611, 2024 is a impute notice, my lord, that has not been served to me. As a result, my lord, I wrote a letter to them. Annexion, my lord, P10,
What not?
page 9/12, 2024.
What not? Without the detail means? Detail is there.
Last annexion.
এটা কত?
They have not given details. My lord, this is a business for 3 months. This is a fishery, my pisciculture, my lord.
Sir, you challenge this under
But against the final order of assessment, your lordship knows me not under section 127, he can prepare an appeal. Without preparing appeal, he has applied for installments that has been granted.
Installment thereafter, my lord, your lordship, even my lord, they have not given
The
details.
writ petition is not maintainable.
Yeah, they have, my lord, I made a prayer.
Since alternative remedies are there, your lordship knows me not.
The petitioner has preferred the present writ petition against the final assessment order dated 28/2024 under section 126 of the Electricity Act 2003. Full stop. Petitioner has been learned counsel for the respondent submits that a provisional assessment order was issued on 12/6/2024 and the petitioner had filed his objection to the same. After granting an opportunity of hearing to the petitioner, wherein he had denied all the allegations that he was not involved in theft of electricity, a final assessment order has been passed. Full stop. This court is conscious of the fact that an appeal is against a final assessment order, an appeal shall lie under section 127 of the
But your lordship kindly consider, my lord,
3.
30 days is the time period for preparing appeal.
That's why he has come here.
As your lordship, my lord, that has.
I'm not passing any order. I'm just dismissing it. Full stop.
Yes.
Since the petitioner has an alternate remedy, alternate efficacious remedy available in law, the present writ petition is not maintainable and the same is dismissed.
And my lord, time may be
Grateful
extended. My lord, only time may be extended so that I may prefer an appeal. my lord.
You have come here only for the extension of time. I'm not extending it.
My lord, I'm grateful to you.
Item number 48.
Lordship. Your lordship, praying short pass over.
No passover. Not today.
Not to.
It's okay.
State. Take it, no.
Item number 50.
Appeared for the respondent number 9.
I am for the.
On the previous occasions, on the previous occasions, I have already filed affidavit in service. Lordship asked me for serving notice again to the Kishonagar municipality.
Who appears for Krishnanagar?
Well, I am for appealing, no?
Lordship kindly see annexure P1 first page 25, my lord.
Page 25.
My lord. Mandatory provisions of engineering was included in note 2047, etc., etc. And base level of rupees 50 lakh for mandatory engineering was brought down to rupees 5 lakh. By notification dated so now in the interest of furtherance of the benefit associated with engineering process in the public procurement and disposal, it has been decided that the basic level of rupees 5 lakh for mandatory engineering process is reduced to rupees 1 lakh. Now, therefore, in exercise of the power conferred by clause 3, etc. So, my lord, it is apparent on the face of the record when the work will be more than rupees 1 lakh. so e-tendering process must be obeyed. But Lordships kindly see.
Yes.
But Lordships kindly see, in no cases that e-tendering process has been followed, which I have stated in paragraph number paragraph number 4 and subsequent paragraphs.
Paragraph number 4.
4 and subsequent paragraphs. For stopping the corruption, my lord, the aforesaid circular has been issued, which I have already shown to your lordships. But my lord, in case of these works, that is paragraph 6, page 6, paragraph word number 4, these works has all the works has been done without any e-tender process. Word number 4, 5, I have stated in 6, 7, 8, 9, 10, 11. In case of beautification, in case of construction of road, in case of hoarding, no, only I was 2 or 3 or 4 tender has been issued.
Who are you?
My lord, we are for the contractors, my lord, of the said municipality who have been deprived to get any work as there is no e-tender process.
So this is a public interest litigation.
No, we are the sufferers, my lord. That's why, my lord, we have come before your lordships. We are the sufferers, my lord, because we are the.
Because you are not given any award. You have not been given any project. That's why you are suffering.
No. There is no e-tender. We are not participating in the process. We are depriving to participate in any process. Our livelihood has seriously been affected. Violation of Article 21 and also 19(1)(g) violation of right to earn by business. That was also violated.
Yes.
My lord, first thing, my lord, in this matter, my lord, I have received the instructions that everything has been done on e-tender, and my lord, I am also having the copy, but my lord, I am not filing an affidavit so that I cannot produce before your lordship. Now, my lord, the thing is that the petitioner, who is this petitioner? My lord? He is seeking a mandamus before your lordship, my lord, without having any locus. He has neither produced any documents to show the see in respect to this there are certain works has been done, and so I have applied, but they have refused it. And my lord, I have the knowledge that his certificate of enlistment in respect to payment certificate of enlistment that has been lapsed long back 2022. Now, my lord, this is lordship, my lord, we have maintained each and everything. Our entire balance sheet has been audited time to time. We can produce each and everything if your lordship wants for your lordship's kind consideration. Not in respect to the locus, my lord, he has filed a writ petition before your lordship. My lordship will kindly see the representation, my lord, what he wants to.
Right, the petitioner.
And by oath, my lord, by oath I have stated, my lord, these works has not been.
The petitioner has filed the present writ petition alleging corruption.
Municipality.
It is stated by the petitioner that he is a contractor who has not been awarded any contract, and the Krishnanagar municipality is legally awarding contract to people, is illegally awarding contract in the municipality. Full stop. In view of various illegalities committed by the said municipality, the petitioner inter alia prays for issuance of writ of mandamus for the appointment of an independent investigating agency to investigate the said illegalities / irregularities. Even though the petitioner alleges corruption in the Krishnanagar municipality, not even a single document is placed on record to substantiate the said allegation. Full stop. No particulars of the alleged illegality is put on record. Full stop. In view thereof, this court is not inclined to exercise its discretionary jurisdiction under section 226 of the Constitution. The present writ petition is dismissed. The from the tenor of the writ petition, it reflects that the petitioner is seeking a roving and fishing inquiry more in the nature of a public interest litigation. उसके बाद कर देना the present writ petition.
Then lordships kindly give me liberty to file public interest litigation. Otherwise,
No liberty is granted to the petitioner. Whatever liberty is available in law, the petitioner can avail.
my lord.
Item number 57.
That matter was heard by my lord, but affidavit service was not ready, for which it was adjourned. Affidavit service is ready with track report, everything.
Yes.
My lord, a representation has been given that an unauthorized construction is going to be made by the private respondent. The petitioner number 1 is a totally blind lady, and petitioner number 1 and 2, they file representation. It is our land, but their chairman is the only authority, my lord. Chairman may be only. I pray that let the chairman be directed to hear out both parties and to see whether there is any illegal.
Who are you, sir?
My lord,
Who are you?
I am the landowner and
Joint
landowner. Petition number 1 is a blind lady, and petition number 2 is also joint landowner. The private respondents are brother and sister, but they're totally constructing house on our portion also. That's why, without any plan. That's why we have given representation to municipality to take steps against them for
5, my lord, that is
affidavit service.
The petitioner has preferred the present writ petition alleging unauthorized and illegal construction on property situated in Dag number 1069 under jail number 17, Khatian 4862 and 4861, Moza Police Station, Joynagar, District, South 24 Parganas. It is stated by the counsel for the petitioner that the petitioner number 1 and 2 and the respondent number 5 and 6 are all biological brothers and sisters. Full stop. Petitioner alleged that respondent number, who's carrying out the unauthorized construction? Respondent number 5 and 6 are illegally and forcefully are illegally carrying out unauthorized construction on the said property. Petitioner states that on 10/1/2025, they had made a complaint to the Joynagar Municipalpur Municipal Authority. Full stop. They have not heard anything on their complaint. Neither any action has been taken on the complaint filed before the municipal authority. You appear for the municipal authority.
Not the state vendor.
Who appears for the municipal authority?
Municipality, none has appeared. In spite of service, they have received everything.
None appears on behalf of the municipal authority despite service. Full stop. This court directs the respondent number
3, get it.
3, the chairman Joynagar Municipal Authority, to decide petitioner's complaint dated 10/1. Where's your complaint?
Annexure P5.
Annexure P5, my lord. Page 23.
Page 23, Annexure P5.
Decide petitioner's complaint dated 10/1/2025 within 4 weeks from the date of communication of this order, after affording an opportunity of hearing to the petitioner as well as the other respondents. With the above direction, the present writ petition is disposed of. Communicate the order.
Yes, sir.
Affidavit of service is taken on record.
Question 59.
But I am for the writ petitioner. The writ petitioner has a property premises in Radha Bajar Street. Now in the by an order dated 16th September 2011, the annual rent was fixed as 1,61,800, and the petition annual valuation has been fixed as 1,61,800, and the petitioner had been paying till from 2011, and the petitioner till date has paid 6,74,699, which we'll get in page number 7. And the petitioner has filed an appeal against the said order, and that appeal was disposed of with the direction upon the annual rent was fixed. When you come to page annual valuation, page number 48. Annual valuation was fixed from 2010 to 2011 at 16,200. The petitioner has paid excess amount. Kindly adjust it with the next payment or refund it.
Yes.
I do not join the issue. What she has said that it has to be adjusted even.
So you decide a representation.
Yes, his representation. I was just going to say that I bow down to your lordship. Your lordship sends it to the assessor and collector south, gives a time frame within which her representation will be disposed of.
All right.
Upon giving a hearing to my learned.
The petitioner has preferred the present writ petition seeking refund/adjustment of the excess amount paid by the petitioner towards annual rent. Full stop. It is the case of the petitioner that by assessment order dated 16/12/2011, the annual value of the premises in question was fixed at rupees 1,61,800. Hence, in pursuance of the said assessment order, the petitioner deposited rupees 6,74,666. Full stop. Subsequently, the municipal assessment tribunal where's that order? Order dated
April 2020.
18th April 2018 in MAA number 1980 of 2011. MAA number 1980 of 2011. Set aside the order passed by the assessing officer and reduce the annual value at rupees 16,200. Full stop. In view of the same, the petitioner asked the respondent for refund of the excess payment made by her. Full stop. However, till date, the respondent has not decided petitioner's representation. Full stop. Being aggrieved by the same, the petitioner has preferred the present writ petition. Mr. Bishudit Mukherjee, along with with Pyali Dasgupta, Pyali Sengupta. I don't know why I keep saying your name wrong. Sengupta. states that they are ready and willing to decide petitioner's representation dated 13/11/2024 within a period of
Well, no,
within a
there
period
will be
of
15 days because the petitioner is.
within a period of 4 weeks, madam. Within a period of 4 weeks from the date of communication of this order, after affording an opportunity of hearing to the petitioner. Full stop. They are ready and willing. The states that the assessor, वहाँ जहाँ लिखा है ना, states that the assessor collector north shall decide petitioner's representation dated so and so. ठीक है? With the above direction, the presented petition is disposed.
My lord, I am filing my affidavit, sir.
Affidavit of service is taken on record.
I'm deeply obliged, my lord.
Password.
Pass over item number 30.
30, my lord, report to be made.
That I appear on behalf of the WBSCBCL. We are directed to file a report, madam. May I hand over a copy of the report?
Get a copy.
No, they are in possession, madam. We have found, madam. I direct the WBSCDCL to give the connection along with police and compliance of all formalities. Though they have not been able to produce any document of ownership, but still is as they are in possession, madam, we have to give them.
In terms of the earlier order dated 18/3/2025, respondent WBSEDCL has carried out the inspection and has handed over a copy of the report. Full stop. Learned counsel for the respondent WBCDL fairly states that the petitioner is in possession of the property. Full stop. They shall grant the electricity connection to the petitioner subject to police protection, right? You are seeking police protection.
Subject to police protection and compliance of all formalities.
Subject to police protection and compliance
Already
of all
complied with.
necessary formalities by
Formalities
the petitioner.
complied with already.
Full stop.
No. The cost of the police will be paid by the petitioner.
If needed.
The
Perhaps
petitioner
police
had
will not be needed.
purchased a plot of land situated at Bilkuli, Nathunpara Post Office, Noipara Police Station, Bhadreshwar, District Hooghly, from the private respondents. Full stop. However, despite the payment of sale consideration, the private respondent had failed to execute the sale deed in favor of the petitioner. Hence, on 5/7/2018, the petitioner had forcefully taken the possession of the said property. Full stop. Since 5/7/2018, the petitioner is residing in the said premises. Full stop. The private respondents had initiated titled suit number 105/2023, and the same is pending adjudication before
the
appropriate court.
I have written it.
The petitioner had applied for a electricity connection
It is in another name,
and had deposited,
not my name.
and had deposited the required quotation amount on 12/4/2023. Full stop. However, due to objections raised by the private respondent, the respondent WPCDL were not in a position to effect the electricity connection. Full stop.
And Manoj, they were not been able to produce the ownership document.
Due to objection raised by the private respondent, as well as due to inadequacy of documents on part of the petitioner, the respondents were not able to grant electricity connection. Full stop. Learned counsel for the respondent, in terms of the inspection carried out, fairly states that they are in a position to grant the electricity connection subject to police protection. Full stop. This court directs who's the OC? Where?
Bhadreshwar. OC, not OC, IC Bhadreshwar.
Bhadreshwar, to provide adequate police protection to the respondent WBCDL to carry out their activities. Full stop. at the cost of the same shall be done at the cost of the petitioner. Full stop.
And my lord, we kindly direct the upon compliance of all formalities, if any.
The respondent states that they shall be granting the electricity connection to the petitioner after meeting with all the necessary compliances within a period of
3 weeks.
3 weeks. With the above direction, the present petition is.
My lord,
dismissed.
kindly add one line.
Yes.
On the previous occasion, I have filed the affidavit of service. Despite service, none appears for the respondents. Kindly record that, my lord.
Affidavit of service is taken on record. There is no appearance on behalf of the respondent.
My lord.
Private response.
Private
response.
I'm grateful, ma'am.
I'll take a break. I'll come back in 5 minutes.
60, Your Lordship, I am appearing for Howrah Municipal Corporation. I am led by.
I am on behalf of the
Sinha.
petitioner. The matter is pertaining to an unauthorized construction which has just been initiated at the plinth level. I am the occupier of the premises and the developer has purchased the premises and he is also an occupier. I am in one portion, he is in other portion.
Where is the property?
41 Hamiduddin Bunsi Lane, Howrah.
Your Lordship, I find there is a representation dated 22nd January 2025, page 54.
Page?
54 is the representation.
Page 54.
To decide his representation.
Your Lordship, we shall do so.
Petitioner has preferred the present writ petition alleging unauthorized construction at holding number
41
41.
Hamiduddin Munshi Lane, ward number 20.
Holding number 41, Hamiduddin Munshi Lane, ward number 20 of Howrah Municipal Corporation, District Howrah. Full stop.
That's taken a relief charge.
Petitioner contends that he is one of the occupiers of a portion of the aforesaid premises. Full stop. He states that respond number
6.
Respond number 6 is carrying out illegal and unauthorized construction on the said property. Full stop.
Well, we
Petitioner
are appealing
states-
for the respondent number 5 and 7.
5 and 7. State. Petitioner states that he had made a representation dated. What is the date of this representation?
22nd of Jan 2025.
22nd of January 2025. Full stop. But till date, he has not heard anything from the respondent corporation nor any action has been taken on his representation. Full stop. Learned counsel for the
Howrah Municipal Corporation.
Howrah Municipal Corporation states that they are ready and willing to decide petitioner's representation dated 22nd January 2025. Full stop. In view of the statement made by the learned counsel for the respondent, the petitioner states that he shall be satisfied if his representation is decided in a time-bound manner. Full stop. This court directs, in view of the statement, in view of the statement made by the learned counsel for the respondent municipal corporation, this court directs the corporation to decide petitioner's representation dated 22nd January 2025 within a period of 6 weeks from the date of communication of this order, after affording an opportunity of personal hearing to the petitioner as well as the private respondents. Full stop. With the above direction, the present writ petition is disposed of.
May it be, Your Lordship, 8 weeks instead of
8
6
weeks.
Great.
8 weeks. Affidavit of service is taken on record.
Okay.
Item number 61.
But in this matter, I am appearing on behalf of the petitioner. I beg to appear on behalf of the private respondent.
Lordship, I am for the Kolkata Municipal Corporation. It is Mohammed yes.
My lord, present petitioner is the owner 1/9 share, my lord. My lord, the private respondent mutated their names before the Kolkata Municipal Corporation as 16 and as owner, my lord. I wrote a letter to the municipality, but they did not take any steps till today, my lord.
Lordship, I am for the Kolkata Municipal Corporation. Lordship, there is nothing on record to show that he was at all a owner at any point of time. So, and it is absolutely a disputed question of fact, your Lordship. The entire petition is liable to be dismissed because what he has annexed with this writ application is only the representation, nothing else, your Lordship. So let him come up with the locus what about his ownership, your Lordship. Then we can satisfy, because the instruction that I have received from the records that is paid, that I have received, your Lordship, is that his name is not nowhere is indicating in the record at any point of time. That is the situation. So this petition is liable to be dismissed until and unless it comes up with the appropriate records.
File your documents.
Yes, my lord. My
This is
father,
only representation that he has annexed.
my father was the owner.
File your documents showing that you are owner of 1/9 or 1/6 or whatever 1/16. File your document.
But I'll take up this matter next week, my lord. I shall produce.
File with the fresh.
I shall produce, my lord.
Nothing
is
there, my lord.
Yes.
This is a matter which went up to the Supreme Court. It was finally
Yes,
adjudicated by the Honorable Supreme Court.
I shall
Partitions route, thereafter division bench, thereafter Supreme Court, and finally we became owner of the property. We have purchased the property from the predecessor in interest of my lord, the gentleman who died. My lord, he is claiming, my lord, to some extent ownership, and his ownership has been denied by everywhere. And my lord, what is more, they have filed one application before the Kolkata Municipal Corporation that was also adjudicated. And without, my lord, the enclosing this particular document, once again he is approaching this honorable court, my lord, in the same fashion, same way. Lordship, he is Giaj by name. Page 2, first paragraph, last 2 line.
Page 2.
2, internal page 2. Lastly, advocate on behalf of so.
Just a minute. Where are you?
Lots.
Advocate on behalf of Vijay Kumar Goel.
Yes. And others have prayed for disposal of the objection raised by the Muhammad Giaj accordingly. Giaj is the petitioner over here.
Yes.
And same manner he is ventilating his grievances before the Kolkata Municipal Corporation. I have got all document, including the judgment and order passed by the Supreme Court, which has been very categorically stated, honorable division judgment, there is nothing to interfere. Actually, accordingly, I can also file my record if my lord permits. So it is not way of a report, your lordship, the records is there. The frivolous writ application, my lord.
The petitioner.
But it is
Present petition.
it is admitted.
Challenging. Just a minute. Is challenging the mutation carried out in the name of private
5, 6, 7,
respondent.
my lord.
In the name of private respondent 5, 6, and 7 in the municipal records. Full stop.
Assessment report.
It is the case of the petition that the premises number 189 Park Street, PO Circus Avenue, within Benai Pukar, PS, in KMC Ward number 60, is inherited by the petitioner along with his other 8 brothers. Petitioner states that he is having 1/9 share in the said property. It is his contention that without his consent and knowledge, his other brothers have sold the property to private respondents. Full stop. On the basis of the said sale document, the property got mutated in the name of the private respondents. It is petitioner states that he is seeking cancellation of the mutation in favor of the private respondents. Learned counsel for the municipality, Ms. So-and-so, appears and states that the petitioner has not put any document on record to substantiate that he is the owner of 1/9 share of the said property. She further states that the present writ petition is bereft of material particular materials and is bereft of materials and shall be dismissed. Full stop. Learned counsel for the respondent, private respondent, so and so appears. Mr. Ghosh. Sorry?
Mr. Raghunath Chakraborty.
Raghunath Chakravarti. Sorry.
Lord, deeply obliged.
Mr. Chakravarti appears and states that even earlier, similar issues were raised by the petitioner and he had sought for cancellation of the mutation earlier too. Full stop. The Deputy Assessor and Collector South, he has handed over an order passed by the Deputy Assessor and Collector South dated 21/12/2021.
If I can place a municipal record also.
Wherein
To the
the petitioner had raised the same issue and the corporation had decided the grievance of the petitioner by way of a speaking order. Full stop. What is this?
Lordship, this is the assessment record, your Lordship, wherefrom it is evident that nowhere his name was any point of time was indicated.
Without
My father's name was there, my lord.
Without getting into the merit of the matter, this court feels that the present writ petition is completely devoid of any merit, since the petitioner has failed to put any document on record showing that he is owner of 1/9 share of the 1/9 owner 1/9 share in the property. Full stop. The present writ petition is dismissed with liberty to the petitioner to file petitions, to file a better petition in accordance with law. To file a petition, better petition with better particulars in accordance with law. 21, the order of वो भी लिख लेना, the is taken on record. The order of the Deputy Assessor and Collector South 21. What is the date?
Assessment record, your Lordship.
What is the date of the order? 21. Mr. Chakravarti, what is the? I'm keeping a copy of that on record. What is the date? 21.
7/9/2021.
No. What is the date of the order? 21.
7/9/2021.
No, Mr. Chakravarti.
Yes, sir.
Date is 21.
21st December 2020.
21st December 2020.
Lordship, along with the assessment record, your Lordship, that I placed, that will also be kept.
I'm not keeping that.
But taking original copy, I'm replacing it. Deeply obliged.
Just give a photocopy.
Yes, sir.
Number 65.
Much. Deeply
Well, in this matter, I am appearing on behalf of the petition. But according to Lordship's direction, that is the translated copy. Oh, and I have served the municipality.
Who appears for Khirpai?
Lordship, I am appearing for the municipality.
Very good.
Well, this is a plot in respect of 1531. This is a pond, and that land was settled by the block land and land reforms officers in favor of the petitioners, and petitioners deposited the amount and he is in possession. That I have annexed the all documents, that is page 12, that is the DCR challan. And that pond is locally known as Queen Pond.
Yes.
Yes.
Yes, sir.
Yes, my lord. This is a plot in respect of 1531. That is the area of the 55 decimals. That is a pond that is known as Guin Pond. And that land was settled for pisciculture in favor of the petitioner. That is 1422, I have annexed, I have
Which page?
page 112,
Page 12.
12.
Yes.
That is that respect of the, I have deposited this amount time to time, year to year. That was 1420, 1421, 1419 to 1422.
So
That
it
is the
got
three-
expired in 21.
21. Thereafter, I made an application before the authority concerned, that is page 15.
Page?
Page
15.
15.
Yes.
I have translated copy given.
Yes.
From 2022, 23 and 25, 3 years, I have made an application before the Block Land and Land Reforms Officer. He is the authority to settle this land.
Yes.
That is still pending. During pendency of this application, that is the page 18, one notice was issued. Page 18.
Yes.
I have annexed the last
Yes.
by the municipal authority for settlement of this pond for
Yes.
this year. It is not the authority of the municipality, it is the absolute jurisdiction of the BLR. That is the land management manual. That is some procedure regarding settlement of the fisheries of the land in question. That is 272.
It's a public notice.
Public notice without mentioning the plot number and known as in respect of the, I am challenging.
Show me. What are you showing?
Yes. 272, that is the land management manual, that is the 272, that is the procedure for settlement in respect of the fishery. That is the absolute jurisdictions of the BLR. In this process, that land will be settled for fisheries and others.
Yes.
Here I am only challenging this issuance of the notice, that is the absolute jurisdictions of the land department.
Yes.
But municipal authority has no power.
Yes.
But they have, without mentioning the plot number and others, they have tried to settle this land and taken steps.
Yes. Yes.
Lordship, the petitioner, there's an admission on part of the petitioner, indirect admission, that he is in unlawful possession of the land.
Yes.
The lease expired on 2014. The petitioner has paid rent till 2014. Rent receipts have been annexed, which are at, as my learned friend has mentioned, in page 12.
Rent he has paid till?
Rent he has paid till 2014 only.
No. 3 years,
2014,
3 years,
2013,
3 years.
and 2012. For 3 years, he has paid the rent. That is not in dispute. After that, he has made applications for renewal of the lease, but it has not been renewed. So, in the absence of a subsisting lease, any possession over the pond is an unlawful possession, and the petitioner is a trespasser in respect of the pond.
Yes.
Now, a public notice had been issued. Auction has been held. the petitioner has not participated in that auction.
Yes.
Therefore, the petitioner has no locus today to challenge the auction.
Yes.
And after the auction, all the formalities have been completed and the possession rights has been given over to the respondent number 10 because he emerged as a successful bidder. Now, your lordship, my learned friend says that he is challenging the auction process on it being unlawful. He has mentioned the same in paragraph number 6 of the writ petition, but there is no prayer apropos his pleadings.
Yes.
There has been no prayer to set aside the auction and conduct it afresh following the procedures.
Yes.
Lordship, I have also received a few documents from the municipality where it shows that the formalities have been completed and the land has been, the possession rights have been handed over.
Yes.
And in this set of documents, Lordship, there is one notice that has been sent to the local police officer which states that the petitioner is in unlawful possession and he may create some problems in while the possession is been handed over. One. Number two, there is a document which has been received from the BLRO which states that Lordship may kindly, which states
Page 17.
That has not been annexed, Your Lordship. These are some documents that have been sent over by the municipality to us. It is stated here that in connection with the above stated subject and reference, this is to inform you that lease is not provided from the office of the undersigned. It is seen from the office documents that Sanat Kumar Bairagi, who is the petitioner herein, son of such and such residing, has made an application on 15/1/2025. You are also informed that no lease was provided to anybody from this office of the above mentioned plot. So, in the absence of a lease,
yes,
the absolute jurisdictions of the bill. I am challenging the jurisdictions of the municipal.
But there has been no prayer.
Yes, yes.
There has been no prayer.
All right, all right. I've heard you. You?
No, I'm appearing on behalf of the state, but
all right, nothing to do. Take down. Take down. Come on. The petition in the present writ petition is challenging the public notice dated 9/1/2025 issued by the chairman, Khirpai Municipality, Paschim Medinapur, whereby inverted comma में कर देना GUIN pond, inverted comma close, comma, a tank was put to auction for pisciculture through open auction. Full stop. It is the case of the petitioner that the respondent municipality had earlier granted a lease in favor of the petitioner for the said tank for the purposes of carrying out pisciculture.
By the BLRO.
The said, full stop, the said lease had expired and the said lease had expired in the year 2014 and the petitioner had been illegally had been in illegal possession of the said tank till now.
Yes.
They are in possession
till date.
Up till now.
Full stop.
But unlawful possession, Your Lordship.
Is in illegal unlawful possession of the said tank till date. The petitioner had written several letters dated 19/4/2022, 4/12/2023, and 15/1/2025 requesting the respondent municipality to extend the lease qua the said pond in favor of the petitioner. However, the respondent municipality
No, I made a representation before the respondent number 7. Before the respondent number 7.
Respondent number 7.
7, that is
Before
the
respondent
BLRO, that
number-
is the authority.
The representation before respondent number 7. However, the respondent number 7 had failed to extend the said lease. Full stop. Even though the said lease has not been extended, the petitioner has been in possession of the said tank and has been carrying out his pisciculture activities illegally. Full stop. It is the submission of the petitioner that being a poor man, his only source of livelihood is this business. Full stop. The petitioner further states that the auction notice dated 9/1/2025 is in clear violation of section 266 of the West Bengal Land and Land Reforms Act.
Management manual.
What is it?
That is the Land and Land Reforms
The
Management
Land and Land Reforms Manual,
Manual.
1991. The full stop. Petitioner states that the public notice has been issued in violation of the said rule. Full stop. It is his contention that he shall be allowed to carry out his pisciculture activities in terms of his earlier lease, which expired in 2014. Learned counsel for the respondent, Kirpai municipality, states that there is no illegality in issuance of the public notice and that all necessary compliances have been undertaken by the authority concerned before issuance of the public notice dated 9/1/2025. Full stop. It is submitted by the counsel for the municipality that the petitioner has been illegally carrying out his pisciculture activities, though his lease has expired way back in the year 2014. It is further contended that the petitioner is illegally and unlawfully occupying the said pond. Full stop. It is petitioner's own case. This court has heard the argument advanced by the parties and has perused the materials on record. Full stop. It is petitioner's own admission that the lease deed had expired in the year 2014 and he has been illegally occupying the said pond and carrying out his pisciculture activities. It is further stated by the petitioner that he has not participated in the tender process, which was in the tender process, which was wherein the said pond has been auctioned. Full stop.
And respondent number 3 has no jurisdiction, I have stated in paragraph 6.
Full stop. The objective of the tender process is not only to adhere to a transparent mechanism, but to encourage competition and give equal opportunity to all the tenderers who are participating in the tender process. Full stop. The respondent municipality, in order to ensure the transparency, had put the said tank for open auction and had issued the public notice whereby inviting all the interested parties to participate in the said process. Full stop. The petitioner, in his wisdom, had chosen not to participate in the tender process. It is well settled principle of law that a party which has not participated in the tender process does not have any locus to challenge the award of the tender and cannot be heard and cannot allege any grievance, as such party does not acquire any right in the tender. Full stop. The effects the petitioner has not been able to show that there has been any violation in issuance of the public notice dated 9/1/2025. In view of the foregoing reasons, the present this court does not find any merit in the present petition, and the same is dismissed.
Deeply obliged, Your Lordship.
The affidavit of service is taken on record.
Item number 66.
Which matter?
Matter which was taken up. Well, I have handed over, my lord, all the documents which your lordship directed, my lord.
Yes, yes.
The trade license and other, my lord, formalities.
Mr. Vishwaroop Bhattacharya.
He knows me by my first name. Joy. Well, the municipality, if it can, my lord, because I do not know, my lord, my instruction is that, my lord, the municipality is taking some measures, my lord, to undo the mischief, if at all, because, my lord, the permission which has been handed over of 2nd March 2015 in the front side wall on upper side of municipal drain, without, you know, this is not on the footpath.
Yes.
You know, he has handed over a permission.
Perhaps this is not there in your lordship's. These three documents, the trade license, the
municipality is here, if can be ascertained from the municipality. I do not know who is appearing for the municipality.
My learned friend's contention is that I have installed an AC machine without permission of the municipality that I have handed over. My trade license is there. The CSC authority also stated before your lordship that there is no problem with regard to my measure. Now, there is a private suit pending against him, wherein he has been restrained from the by the learned trial judge from disturbing my possession. That injunction is still subsisting. There is an application under section 151 for police implementation.
Yes.
He being the promoter, he wants to make up a building over there. He wants my eviction by.
I am the promoter. If he can prove that I am the promoter, I don't have a case.
But he has a permission for the yes.
Please keep.
Yes, yes.
Lord, I do not know what permission he is speaking of, my lord.
I have handed over.
This is the
Just hand
permission.
over.
My instruction before Mr. Nag makes any submission, the permission that is being kindly sees the permission once. The permission and kindly compares it with page 22. The permission was for installing above some drain, municipal drain. It says on the in the front side wall on upper side of municipal drain without making any obstruction. Not on the footpath. Not on the footpath. First, apart from this, let Mr. Nag inform you.
Lord, so far as the construction of a structure on the government land on footpath is concerned, my lord, there is no permission. If that is a document they are relying upon, my lord, I do not know that the chairman might have passed and that chairman has gone, my lord. What provision of law he has passed, we do not know. The Board of Councillors, as on today, cannot consider that
you decide his representation.
That means
Lord,
they can decide.
We have already held inquiries. They participated in the inquiry. They can have. We have no problem with the AC machine. They can put it wherever they want. Not on road.
Let them instruct me where is
Will kindly record, my lord, on as per the inquiry of 21st February, it was found that they have constructed something on road beyond the building.
Take action.
Yes, yes, no. We have
already. They cannot say we will demolish. They will have to pass an order.
The engineering department has already directed the demolition department to clear off the encroachment. We will clear it off.
My lord,
If the
the
matter
law-
was pending, my lord, we were not.
My lord, subject to
We are not
correction, my lord,
taking
only one thing, subject to correction, 218 of the West Bengal Municipal Act suggests, as my learned friend is saying, that the Board of
Okay, ma'am,
Council
that's
has
okay.
taken a decision. My lord, they will have to give me a hearing. Thereafter, 218, they will have to pass an order. My lord, the order has to, my lord, your lordship on the last day also consider that is a self-demolition. My lord, they cannot say, my lord, I will, my lord, they will directly remove it. My lord, they will direct me to undo the wrong.
On a footpath,
Yes, yes.
But they will certainly direct me to undo the wrong. If I could not able to do by myself, not then they will certainly not take it. Law take its own course and they will demolish.
Let me tell you one thing.
Why?
The little understanding I have of municipal law.
Why?
Is that any encroachment
No,
on
because
public,
they cannot-
just a minute, sir, on public land, which is in the form of a footpath or any government land, can be removed without issuance of any notice.
Not subject to correction, my lord. Today, my lord, it's just adjoining my lord wall. My lord, your lordship has seen, my lord, the photograph.
It is adjoining your wall, which
wall.
would mean
My lord, the AC machine, your lordship.
it is on the lid. I don't know what is your understanding of municipal law. Even if you have a chajja, right, and it is protruding on the government land, though it is nowhere connected to the road or to government land, that will also be demolished.
Very well, my lord, they will have to come
So
to a
if
conclusion
if
that
your
this-
AC unit
Yes.
is on the government land
my lord, they
or
will-
on the footpath, it can be removed
I
and
bow
without
down,
giving
I bow
any
down, my lord,
notice
they
to
will
you.
have to come to a fact finding.
I guess that is what the law should be here also.
That is, my lord, that they will have to come to a conclusion that yes, my AC machine is encroaching upon the footpath. Let them do so.
That is
My lord,
something which
not
would be
something,
evident.
not from your lordship, not a hearing has been taken place. They will have to
What do
communicate me
you,
the
Mr.
decision.
Nag, what do you want to do? You want to decide his representation or?
My lord, we are already deciding upon our findings are that his AC machine is not within the premises. It is on the
Well, let them
footpath.
serve that. They have taken a decision, my lord, that has not been communicated to me.
What do you want this court to do? You want me to decide, pass a direction to
My lord,
decide?
kindly record my submission and thereafter, my lord, will direct us to serve a reasoned order. We will send us.
That. I'm good. I'm good.
All right.
No, no,
You are a busy counsel, Mr.
Quotum number one.
More money to make.
Huh?
More money.
That is not money. That is for, pro bono.
My lord, Mr. Bhattacharya never, my lord, works for money.
Pro bono work.
Pro bono only.
Not never. Otherwise, how will I sustain?
My lord, I'm appearing for CAC, respondent number 3 to 5. But my lord, the instruction I have on our part, there is no unauthorized use of electricity on their part.
You don't have to look into that.
My lord.
Filed by the state captain.
What is your report?
Well, it already been submitted on the self-same cause of action. There is an injunction order by the learned tribe.
No. There is no injunction.
No, my lord, there the municipality is not.
The petitioner is agreed by.
এই petitioner সাথে সেটা কিন্তু তোমার মক্কেল সাবমিট করে
আমি জানি আছে রেকর্ডে জজ সাহেব
And order.
Look, may I be?
Yes, Mr. Nag. So I'll just record your submission. Your junior is here, right?
Miller, my junior is.
She is aware of the case.
Miller.
The petitioner is agreed by the inaction on the part of the municipality in not removing the unauthorized and illegal setting up of a AC unit.
There are several allegations. Your lordship is dealing with this because others blood has been written.
AC unit, which is encroaching upon the public footpath. It is the case of the petitioner that the positioning of the air conditioning machine and the signboard of the said shop are placed in such a manner that it is causing obstruction and inconvenience to public pedestrian walking over the said footpath. Full stop. Learned counsel of the petitioner, learned counsel of the respondent states that they are in the process of they are contemplating action and are in the process of removal of any unauthorized or illegal encroachment on the pedestrian footpath. Full stop. Learned counsel for the petitioner refutes the said allegation.
Private respondent.
Private respondent refutes the said allegation and states that there is no obstruction or encroachment on the public footpath and that they have installed the said AC unit in accordance with the duly granted permission. In accordance with the permission duly granted by the municipality. Full stop. Be that as it may, learned counsel with the respondent submits that they are ready and willing to decide the representation of the petitioner dated 20th January 2025, full stop. In view of the said submission by the counsel for the respondent, corporation, petitioner states that he shall be satisfied if his representation is decided in a time-bound manner. Full stop. In view of the same, this court directs the respondent corporation to decide petitioner's representation dated 20th of January 2025 within 6 weeks from the date of communication of this order, after affording an opportunity of personal hearing to the petitioner as well as the private respondents by way of a speaking order. With the above direction, the present writ petition is disposed of.
Only instead of corporation, your lordship direct the municipality.
Municipality. Corporation, municipality.
Extremely grateful. Lord, the permission should retain your lordship's record. I shall take back.
You take it back.
Mine.
Affidavit of service is taken on record. Give him the permission. वो
तीनटे पेपर को फेवर दिया
वो दे दो वापस.
Item number 67.
The statement.
Lord, I am for the petitioner, my lord. The petitioner before your lordship, my lord, for non-payment of the pensionary benefits, my lord, family pension, my lord.
Lord, I am for the municipality.
For the corporation.
Corporation. Lord, the fact is this, the husband of the petitioner who asks for the family pension, Lord, the was
Surjit, ये नाम और नंबर लोन.
had been working as unapproved. So there is some correspondence. After completion of the correspondence, it converted to approved post and ultimately to issued. From next month, he will get the family pension.
My lord, kindly see the PPO, my lord. I already in the next occasion, earlier occasion, my lord, I hand over a copy of the PPO.
The process completed.
Can you
Next
see the
month,
PPO?
from next month, she will get the family
Yes,
pension.
PPO is here. I have a copy. I have a copy.
The family pension, my lord, this is issued from 1st May 2022 to my lord, started. But from 22 to my lord, the till date, my lord, not a single penny has been disbursed. Kindly see, my lord, the first block family pension, B family pension, my lord.
This was 3-4.
The EPF, EFP 25,900, my lord, from 1st May 2022. Enhanced family pension.
Yes.
No, from 2022, my lord, it was, my lord, they had not been disbursed.
It will be effect from that day. But in the meantime, correspondence has been completed. That he had been working in the unapproved post.
File your reply. Learned counsel for the
Well, kindly ask them to release them.
Release automatic
file your reply in a week's time. Put everything on record. Learned counsel for the respondent.
Area pension.
Learned counsel for the Navdeep municipality
Record
has entered appearance and seeks 1 week time to file a report indicating as to actions which have been taken to release the pensionary benefit
and my lord, the
of
death
the
benefits
petitioner.
also. Once in service.
You file within 1 week. We'll keep it after 10 days.
After
10 days.
3 weeks time.
Listen, this is pension. This is not construction.
Lordship, kindly, pension will be handed over on April, within 3 days, 2 or 3 days after.
Should I record that?
Yes, it is over telephone instructed me that property ready, be handed over to.
Should I record it? That's why I'm giving you 1 week time.
Yes. 10 days time.
10 days time. After 10 days.
Immediately, there is a direction to serve call notice only to service.
Affidavit of service taken on record.
Grateful.
7th April. 7th April.
Petition number 69.
69, my lord, I have taken out an
My lord, I am for the petition.
My lord, this writ petition I find, my lord, is taken out at the instance of, my lord, a partnership firm. My lord, there are 2 partners. One is the writ petitioner number 2, I suppose. My lord, the other one is myself.
That matter, well, I have taken the maintainability point. The second petition is not maintainable. Earlier order, my lord, is there, same prior, same party.
Yes.
How the second petition maintainable? That
Yes.
they took time.
They took time
to argue the
Yes,
matter.
yes.
May I try and assist your lordship on this?
I'll tell you one thing.
Yes,
If
my
I
lord.
dismiss it, I'll impose cost. I'm
My lord.
making it clear.
As an
No, this I will not tolerate. People can't come to this court and keep filing cases on the same cause of action.
This is possibly not on the same cause of action.
If it is not good for you, but if it is, then bad for you.
Kindly allow me to trouble.
50,000 cost, I'm indicating right now.
Same pair, same pair.
May I?
50,000 cost. That's why I gave you time to seek instruction.
That's true.
Don't take the court for a ride.
No, we have
They will not allow this court to be taken for a ride.
Our
These
instruction.
kind of petitions can't be filed. Sorry, sir.
Our instruction is to
So
try
I'm
and
also
convince-
making it very clear to you. Your instruction, my direction. You
Absolutely.
only have
Absolutely.
instruction, I'll have a direction.
Absolutely, absolutely. And
You
we always
tell your client to be burdened with the cost.
if
Then you take it in appeal and get the cost reduced.
if my lord kindly tolerates me, for 5 minutes or 10 minutes.
Sir,
by
I am
the
making
clock.
it very clear.
True.
As a lawyer, you are well aware of what kind of a petition you have filed.
Yes, my lord.
First, you are officer of the court,
Yes, my
and then you are representing your client.
absolutely, my lord. Absolutely, no doubt of it.
So
No
be
doubt
fair
of
to
it.
the court.
Yes.
If
my lord.
in the earlier round of litigation, issues have been decided,
Yes, my lord.
adjudicated upon,
Push.
do not press the same cause of action in the next writ petition.
My lord, in my humble understanding, my lord, this is a fresh cause.
Good.
And my lord, possibly, my lord,
Good.
my lord, I'm sure, my lord, I'm not
No, good,
annoying your
good.
lordship, my lord, on
No,
this.
no, it's not the question. I'm just making it very clear to you that I will not tolerate this.
My lord, I sat with the client, my lord, my learned advocate on record, my lord, and my learned junior, my lord, sat with the client. My lord, the instruction that we received, my lord, is, my lord, to try and convince your lordship, my lord, very pithily.
Yes,
If
try.
my lord kindly tolerates me, my lord, for 5 or 10 minutes, my lord, by the clock. My
10
lord,
minutes, 10,000.
I'm
Yes.
sorry, my lord.
10 minutes, 10,000.
My lord, I will not
I'll-
take more than 10 minutes of my lord's precious time. My lord, I'll not.
Yes.
My lord, I'll conclude, my lord, in the first step. My lord, the order, my lord, which was passed in the earlier round of litigation, my lord has kindly seen that order at page 52. If my lord kindly once again take the trouble, my lord, just to have a quick look at, my lord, the previous order.
Page 52.
Yes, my lord.
Yes, sir.
Madam, I believe, my lord, I'm not, my lord, as an officer of the court annoying your lordship. Then, my lord, I will not open my mouth. But I know I am taking a risk, a chance. My lord, kindly allow me, my lord, just to trouble your lordship for 10 minutes, my lord, by the clock.
I have made it very clear to you, sir.
That's true.
Tell
My
me.
lord, kindly take, my lord, page 54, the ordering portion. My lord, the order was to direct, the municipality was directed to take steps to issue, my lord, the trade license. And then, my lord, the next paragraph says, steps are to be taken within 4 weeks. Now, my lord, pursuant to this order, my lord, they, according to their wisdom, my lord, took steps by calling upon, my lord, the partners of the partnership firm, so-called partners, my lord, to attend a hearing. My lord, I am against these so-called steps taken for, my lord, renewal of the trade license, which was not there in the first round of litigation. I say, my lord, these steps are not in accordance with law. This is, my lord, precisely my case. I say, my lord, the steps that they have taken in the guise of compliance of the previous order are not the steps which are warranted under the statute. So, my lord, I say that, my lord, this is absolutely, my lord, a new cause of action because they have now, my lord, arrogated themselves, my lord, powers which are not conferred upon them by law. Now, my lord, on this, my lord, I will quickly rely on, my lord, a few decisions. According to them, my lord, the first judgment first. I'm sorry. My lord, I'll be as quick as possible. So, whether steps were required to be taken in accordance with law? They did not take steps, my lord, in accordance with law. They rather, my lord, acted in excess of their jurisdiction. When it comes to, my lord, issuance or renewal of a trade license, the only limited scope of inquiry is to see whether I am sitting there or not. Nothing else. And whether, my lord, the proposed business is illegal or legal. These are, my lord, the two limited points on which, my lord, they have to satisfy themselves. They cannot call upon the other partner to resolve a partnership dispute. That's pending arbitration and pending adjudication in an arbitration. So, this is a new step taken in alleged compliance, in the guise of compliance of the previous directions passed by an honorable coordinate bench, which gave rise to the new cause of action. Now, my lord, before I say that, my lord, contempt is not, my lord, a substitute for a second writ petition, my lord, may I place reliance on 2-3 decisions of, my lord, our honorable court, my lord, of course, subject to my limitation of understanding. May I, my lord, hand up? If my lord kindly permits me, my lord, to hand up. Just have hand. May I, my lord? I'm so grateful, my lord, to your lordship. My lord, the first judgment is reported at 2003, volume 1, CHN, page 154. Kindly, my lord, straightway come to paragraph 6, because, my lord, I have to be quick. Paragraph 6, my lord.
Just
says, my lord, contempt is not, my lord, an alternative for, my lord, a second writ petition for implementation of an order passed in an earlier writ petition. That's, my lord, the law, my lord, laid down. My lord, the same law, my lord, is laid down by the Honorable Apex Court as well. My lord, in 2007, volume 7.
Just read. What are you reading?
Yes, my lord. Paragraph 6. It is therefore settled law that the second writ application is maintainable for implementation of an earlier order of the writ court. This court must issue proper directions for proper implementation of previous directions. Where there has been an order, the order must be complied with. An act done in willful disobedience of a court order is not only contempt, but also an illegal and invalid act. The language used in Article 226 is couched in comprehensive phraseology, and the said article recognizes a very wide power on the High Courts to remedy injustice wherever it is found. This is, my lord, reiteration of the phrase, my lord, ubi res ibi remedium, ubi jus ibi remedium. That's what, my lord, the Honorable Coordinate Bench had said. My lord, a second writ, in my humble understanding, for implementation of an order passed in an earlier writ is very much maintainable. The same law, my lord, is reiterated by the Honorable.
First, you tell me the facts of this case. Without running here and there, tell me the facts of this
Of,
case.
my lord, the case in hand.
Yes.
Yes. My lord, I tell you, lordship. My lord, a partnership firm, my lord, runs a business of, my lord, a oil mill, my lord, mustard oil mill.
Yes.
My lord, the partnership firm, my lord, was constituted, my lord, initially in 1980, on, my lord, 21st August 1980. Then, my lord, reconstituted on 1st April 2010.
Yes.
And then there was, my lord, a further reconstitution. Now, my lord, trade licenses were there. My lord, the partnership firm was running the business. Then, my lord, there was a dispute between the partners inter se, which, my lord, led, my lord, to a civil suit being instituted. My lord, in the suit, My lord, there was an injunction order passed, my lord, by the Civil Judge Junior Division Second Court at Barakpur, my lord, injuncting them from withholding trade license. My lord, I have not annexed the order, but pleaded, my lord, at page 5, paragraph 9, and which also finds reference, my lord, in the order passed by the Honorable Coordinate Bench in the previous round of litigation. That's it, finds reference there. My lord, despite this order being passed, my lord, the trade license was not being issued. So, my lord, I approached this Honorable Court. And, my lord, the first round of litigation took place before this Honorable Court in the earlier 226 application, and the order at page 52 was passed. What has happened after that, when the order was communicated, my lord, they called us for a hearing. And, my lord, they made it clear that, my lord, they are not going to, my lord, renew the trade license and withholding this because of the disputes between the partners inter se. And they wanted to hear, my lord, the other partner who is no more a partner because the partnership deed has been reconstituted. But be that as it may, my lord, these are all disputes between the partners inter se, which is, my lord, pending adjudication in an arbitration proceeding. My learned friend is appearing for the other person who is now
I have taken out an application.
Lord, I'll deal with that. Who is projecting himself to be
What
Miller?
application? I don't have any
For
other
addition of
For
party,
addition
because I
of
have
party.
not been made a party in this.
But I say, Miller, he is not a
Application?
necessary
Can
party.
one, Miller?
We don't- I don't have
Today it
can
was
one.
made returnable, Miller. Today it was made returnable.
I say, Miller, this is
What is this
absolutely.
application?
Lord, my application for addition of party, because I am a partner,
Yes.
Lord, I have issued a dissolution notice. The partnership is at will. So, my lord, today there is no partnership firm. If there is no partnership firm, the business cannot continue. And in absence of any business, the question of issuing trade license cannot arise.
These are neither
Lord,
here
these
nor there.
were not germane at a point of time
All right,
when the
let me hear
previous
it.
order was passed.
Let him hear.
Right.
Let me hear. Yes.
Should I, Miller, come back?
After lunch.
So grateful, Miller, to you. So grateful.
Lord, Lordship's pleasure, Lord. Today, there's a bereavement of in my junior's family, Lord.
Lord, I'll come back any day that is
Tomorrow,
convenient to your lordship, convenient to my
Lord,
learned friend, any day.
We'll have it tomorrow.
Tomorrow.
And Miller, kindly do not take
Not-
me
not
amiss, Miller. Miller, I was trying to, Miller, just to.
No, we'll have it tomorrow.
So great.
I'm obliged.
So great.
compelled circumstances, your losses have come before your losses for grant me leave to file this restoration application without server copy, my lord. Because, my lord, the petitioner is a senior citizen, my lord. He has been dispossessed from his residential premises without having order of eviction.
So what?
So I was coming from my chamber, but I was blocked at traffic signal. That is
That's
why
okay,
I
mention
couldn't
it
attend.
tomorrow. Mention it tomorrow, sir. Tomorrow.
Great.
Item number 75.
Petitioner.
Lordship, I appear on behalf of the writ petitioner in this matter.
I'm for the private respondent, my lord.
Lordship, I'll just tell your Lordship the background briefly. Lordship, this is with regards to a plot bearing number 2089. This happens to be initially a Doba plot. A Doba plot, your Lordship, would be the the English synonymous of it would be the plots on which it is riddled by swampy lands. So it is not fit for construction. What has happened over here, your Lordship, the private respondents who have the purported owners of this particular Doba land, they have filled up the land and erected certain constructions in the year 2022. After that, I make certain complaints to the local police authorities and the municipal authorities, pursuant to which the construction then stops. There is a there's a Section 6 application under the Right to Information Act, which I prefer before the municipal authorities, to which they reply to me, ascertaining that there is no building plan with respect to the said premises. Subsequently, your Lordship, in 2024, in the month of July, again they start erecting this premises further. Now, your Lordship, I am prejudiced because I am the owner of the adjacent plot of land. If your Lordship, I'll just proffer the relevant documents to your Lordship. What is happening is the ingress and egress to my plot of land is being hampered because of their illegal constructions. If I may just showcase 3 documents to your Lordship, Lordship will firstly take page number 22 of my writ petition. It is the reply from the municipal authorities. Your Lordship is with me. Page number 22. This is to inform you that no building plan has been sanctioned in name of Sri Kalipado Sikdar at premises Dag number 2089. This is the subject premises in dispute in the present writ petition. Your Lordship, one more aspect I must disclose in the interest of fairness. There is a civil suit which was instituted by by the clients of my learned senior on the other side, wherein they have obtained an order of injunction. Your Lordship, it is apposite that I place that order of injunction at the inception in the interest of fairness, page number 39, Your Lordship. However, my humble submission in this regard, Your Lordship, is that this particular order of injunction, it is only with respect to the possession of the suit property that they have agitated. Your Lordship, subsequently, after they've stopped the illegal construction in 2022 and in July thereon of the last year, they go on with further erecting structures on that particular premises. Your Lordship, I have made a complaint before the municipal authorities, which Your Lordship would find on page number 24. I apologize for being so haywire with the documents, Your Lordship. 24 of my application. Conjointly, I have also made representations before the local police authorities. However, Your Lordship, as on date, my instructions are there is no action that has been taken on the part of the respondent authorities to cause any investigation or anything with respect to these illegal structures that are being erected.
Read that order of page, the injunction order.
Your Lordship would find that on page 39. If I may place it with Your Lordship's kind leave. The defendant, which is my father, and or any person related with him in any manner, is hereby restrained from doing any activity which would create disturbance, annoyance in peaceful possession of the suit property as mentioned in the schedule of the plaint as possessed by the plaintiffs, or blockage, creation of obstruction for ingress and egress to and from the scheduled property in the matter. Your Lordship would find the plaint is also annexed, the schedule
Your Lordship would find it on page number 36 of my writ petition. However, Your Lordship, my humble submission is this is only with respect to the possession. I am in no way tampering or inhibiting with the possession of my of the private respondents hearing. The limited surmise where I come from, Your Lordship, if Your Lordship has a look at page 40. Page 40, the map is there. Your Lordship would, it's a little hazy in my copy. I hope the copy that has been proffered to Your Lordship has a better picture. Your Lordship, in the lower portion on the right side, 420, owners of this land, 1, 2, 3. I happen to be the son of 3. Subhashish Nundi. Your Lordship, on top, Dag number 2089, that's where the purported illegal constructions are taking place. Your Lordship, so the road, which is further on top, Your Lordship, there is no. Your Lordship is with me. Yes. So, Your Lordship, the road, so these constructions, they're not only encroaching upon my part of the property, also on the narrow leeway that is on the right of 2089, which is inhibiting my ingress and egress. Be that as it may, Your Lordship, even I can satisfy Your Lordships on the aspect of locus merely on the point that there is no sanctioned building plan to that effect.
My lord, there is an admission on the part of my appellant petitioner that there is a dispute. So ongoing dispute is there between the parties. And first of all, my lord, can you seize, my lord, the parties to the writ petition? Howrah Municipal Corporation is not made a party. They are all officers are made a party. So main grievance is against that inaction on the part of my lord.
Oh, sir, it doesn't matter.
My lord. My lord, my next point is that, my lord, be that as it may, whether the construction is legally made or it is an illegal construction, my lord, that is required to be, my lord, decided by the municipality.
Yes.
So, my lord, I am not standing on that way, my lord. So, if it is assessed that it's an illegal construction without authority, my lord, action may be taken in accordance with the law. I am not standing on that way. What I am on, my lord, that the dispute that, my lord, depicted by my learned friend in respect of the properties are adjacent. So the virus of the dispute is civil in nature. And as far as sanction plan is concerned, my lord, is required to be assessed.
Firstly, in the civil code, my lord, I can find from the paper that in the civil code, Howrah Corporation is not a party.
Doesn't matter, sir.
It's not a party. There.
Your officers are party. Your commissioner is a party. Your
Anything in the civil suit. In the civil suit, I'll make the Howrah Corporation a party.
About that. Now, next, my lord, 177(5) says no court shall entertain any suit against any order of the unauthorized construction by the commission. So, in this case, my lord, we will make an inspection. If there is no plan, we will take steps against 177. Under section 177 of the.
Well, it is required to be assessed, whether it is legal construction or illegal construction.
No, without plan is always illegal.
So, my lord, it is required to be.
So, my lord, I have prima facie indicated to your lordship that it is without a plan as per the.
File a report.
Let it be.
Your lordship, in the meantime, let some protection be accorded to me with respect to that no further construction be made in.
Well, he is not going on since 2022, right?
Your lordship, after that it had stopped, which is why I have not agitated
Where is
these.
that?
Your lordship,
where is the work stop notice?
Your lordship, they have not issued a notice upon my filing of.
How do you know they have stopped?
Your lordship, that is my instructions. Again, I do not.
Don't make that statement.
Yes, your lordship, I apologize.
The petition, the present petition is challenging the unauthorized construction at Moza Dasra jail number 05, old plot number 2089, PO GIP colony, PS Jagacha Havra under district Havra. At the instance of private respondent number
6 to 9.
6 to 9.
6 to 9.
7 to 9.
7 to 7,
7,
8, 7 to 9. Learned counsel petitioner states that the ongoing construction is going on without having any valid sanction plan. Learned counsel for the respondent, Havra Municipal Corporation, seeks and is granted. How much time?
3 weeks,
3 weeks time to file his report after conducting an inspection, on-spot inspection. File a report after 3 weeks. Let this matter be listed after 4 weeks.
So the affidavit of service may be kept.
Affidavit of service is taken. Affidavit of service is taken out.
Grateful, my lord.
Grateful to you.
Item number 78.
I beg to appear for the petition. My lord, this is a municipality matter, my lord. Municipality has been served, my lord. They are not appearing, my lord. My lord, my representation at page 20 may be disposed of.
Which
For-
municipality?
Burdwan municipality.
How have you served them?
My lord, by hand, my lord.
Mr.
Mr. Subhasis.
Sandeepan, Mr. Banerjee. Mr. Sandeepan Banerjee.
Sir, that's happening.
Who appears
No, this
for
is
Burdwan?
Mr. Subhasis Bandopadhyay.
You serve him,
Mr. Subhasis.
serve upon him. Affidavit of service is taken on record. Learned counsel the petition is directed to serve upon the respondent corporation afresh. List next week. Wednesday.
Item number 82.
I'm for the petitioner, my lord, led by Mrs. Pompa De Habal, my lord. I'm praying for not this week, my lord. She could not come today, my lord, due to that her mother-in-law.
Yesterday also you saw
Yes,
time.
my lord, yes. Also, she.
You said the mother-in-law is not well or something. What did he say?
My
Saw
lord.
date yesterday also.
Yes, my lord. She is hospitalized, my lord. His mother-in-law, my lord.
Not today.
Not this week, kindly, my lord.
Not this week.
Grateful.
Item number 83.
Lord, 83, my lord, in this matter, I'm administrative Dhituan marriage matter. He is in his list for court number 236, my lord.
Sorry?
My lord, in this matter, I'm administrative Dhituan marriage matter. He is in his list for court number 236, my lord. Kindly make it pass over.
Passover.
Where is the representation to be considered, madam? That can be passed, madam. 27 January 2025, the allegations of unauthorized construction have been made. That representation we can consider if subject to your lordship's approval.
False allegation, my lord. My mother-in-law purchased this room, one room, my lord.
Maybe representation can be considered.
Let the commission decide the representation.
My instructions were just to ask for a Passover, my lord.
Have it tomorrow then. Proxy counsel so and so appears and states that the main arguing counsel is in some personal difficulty. Let this matter be listed tomorrow. We'll have it
Wednesday.
Wednesday.
Wait. Wednesday. Wednesday. Report, you know.
Give your name.
Grateful. এখানে দিয়েছি
না আমি প্রাইভেট
Item number 84.
corporation দিয়ে দিয়েছি
Meet please, lordship, my lord.
Yes.
Lord, the matter pertains to an unauthorized construction raised by the private respondent, my lord, without a sanctioned plan, or my lord, in violation of the plan.
It need.
Now, my lord, if my lord sees the allegation that is made in the writ petition, my lord would find, my lord, that the mandatory required open spaces has not been left by them. We have annexed photographs. My lord may direct the municipality.
Sure.
My lord may direct the municipality to take up a proceeding. Our complaint is at page 41.
I'm a neighbor. So, my lord, we have given the schedule. My lord may come over to the third page. After purchase the below scheduled land, she has constructed one-story house violating the mandatory minimum open spaces with respect to the height and category of the building as engrafted under the established law of land. The minimum open spaces are required for maintaining the stability of the building and its adjacent building, which has been grossly violated, and an illegal construction of one-story house has been made over the below scheduled land property by so-and-so. Lord, under 218 of the West Bengal Municipal Act 1993, Lord, the Board of Councillors are the appropriate authority. My Lord may direct the Board of Councillors of Lord Rajpur Sonarpur Municipality to Lord hear both the parties, inspect the property, and take a decision. If it is illegal, they will take steps. If it is not illegal, they will Lord dismiss my complaint. That's the only relief I'm asking.
For the municipality, you?
Lordship, I am for the municipality, Lordship.
Yes.
Lordship, they have
সেটা করতে
submitted the representation on 25th, Lordship, January. Lordship, on the previous occasion, Lordship directed the petitioner advocate to take instruction whether his construction was legal or illegal. That is was in that that was
that I can address. That I can address if there is any doubt or in your lordship's mind, I can address. I have taken instruction to that.
The petitioner has not disclosed his
Yes, I tell you, lordship, not
ownership.
my predecessors have purchased the premises in property in 1963. Lord, the Punch 1963. I am carrying the deed. Lord, I'll hand it over to your lordships. Lord, the Panchayati Raj Act for the first time came into force, Lord, in 1957. I am carrying that act with me. In that act, there was no provision for sanction of a building plan. Then that act was later on amended. I have prepared a print. I just give you lordship 2-3 dates. Kindly bear with me for a second. Lord, my father purchased the property in 1963, 31 decimals. The West Bengal Panchayat Act for the first time enacted in 1957, the 3-tier Panchayat. Lord, my father constructed the house in 1964. Lord, the Panchayat Act thereafter was amended. Lord, in the year 1964, West Bengal Panchayat Amendment Act came into force. There is also no provision for obtaining sanction building plan. The provision for obtaining a sanction plan for construction in a Panchayat area for the first time came in 1973 through section 23 of the present Panchayat Act. These are the undergone amendments, Lord, but the act is present. Earlier act has been repealed. 1957 Act, if my lord sees 218 of the Panchayat Act, Lord, the earlier act has been repealed, 1957 Act. Our construction, the house that we are staying in, this came in a much later stage to the municipal area. My lord, a municipality is constructed, my lord knows, as per 245 of the constitution, my lord, that whenever there is a population of more than, I am not sure about 1 lakh or something like that. Initially, this area was within New Goria Panchayat. Then it was given to Lord, the municipality. So today the dispute is not whether I have made any construction. My house is there from 1964. They have never initiated any complaint. There is never any complaint or any proceeding. Today we have only alleged that the private respondent has constructed a new building without maintaining the proper steps. Let them inquire on that. Lord, the law never demanded me in 1964 to obtain a sanction plan. There was no provision at all. My lord may have a look at, Lord, I'm so sorry. I got a printout from the internet, but not the act is available in Sarthak. My lord may have a look at it. Lord, I have from my iPad. I'm so sorry, my lord. My lord may have a look at it. That is your lordship doubt, Lord. This is only an effort. There is no provision, Lord, subject to correction by my lord, Lord, to get a plan sanctioned in 1957.
Which provision here?
Lord, there was no provision for a sanctioned building plan in 1957, subject to correction by my learned adversaries, Lord. Lord, the issue is not whether my house is legal or illegal. The issue is a new construction. Kindly take, Lord, page 41 of the writ petition. A brand new house is coming up. Kindly have a look at it. Page 43. This is the property. It's a new construction. So here, if they don't leave the mandatory space, whatever is required under the law, the municipality may do it. My lord, I really, I am grateful that your lordship was trying to put a check. I completely bow down because people are coming with petitions in galore. There has to be, something that people are coming with a good, intentions. I tell your lordship this. So here I have inquired that deed of 63 I am carrying. So at that point of time, there was nothing. And the Panchayat Act also strangely, section 3, if my lord sees, the sections were not.
So many petitions are filed. It's so difficult to figure out that
Lord-
which ones are being filed with a vested interest and the
Absolutely.
ones which are being filed.
Absolutely. Lord, I on the last occasion I was addressing Justice Kaushik Chando, but I told his lordship, Lord, that there has to be, there are many litigations I will find after an interim order, people are not coming. Dismiss for default, withdrawing.
Because there's a settlement.
Yes, I file a writ petition,
But
then
this
there is an
not-
order.
This is not privy only to this.
Yes.
It's everywhere.
In municipal determination, it is at galore.
Not only here,
Absolutely. My lord has experience.
everywhere.
My lord had been in the bar for so long and my lord knows.
Actually thrive on this business. It's a business.
Yes. Yes.
Wherever they see any construction being carried out, they'll file a writ petition.
Yes. Yes.
Then
Some sort of inquiry, your lordship has done it, Lord. I'm so grateful to your lordship. But here, as per my limited understanding of law, there's nothing there. My lord may direct them, the board of councillors, to dispose of my writ petition in accordance with law upon hearing both the parties. Thank you.
I guess you don't have any problem in deciding the representation.
Lordship, kindly have a look at page 26 of the writ petition, Lordship.
26.
Hmm.
Seta ki go?
Dolil, private respondent, Dolil.
It is the deed of the private respondent.
Lordship, all that such and such Vastu land along with 100 square feet, cemented flooring is tile shed,
Yes.
residential structure standing
He has
there.
constructed a one-story building, that demolishing that. My complaint is page 41. They will only consider 41. Actually,
না এটা ডিসিশন নেব না আমি বলছি যে এরিয়া অফ ল্যান্ড সেখানে কোনো প্ল্যান স্যাংশন বা কিছু হতে পারে না তো
কেন? Page 26 you see?
এরিয়া অফ ল্যান্ডটা কত?
Yes. The 1.2 decimal of Vastu land. Along with 100 square feet construction. What my learned friend is saying, he is mistaken.
Area of land is very
1.28 decimal.
very quantity of land is very
Then
less.
there cannot be any
Doesn't make
plan.
a difference.
Yes.
Lordship,
You can have a construction even on a
Lordship, that is the issue.
20 square yard plot.
You do that inquiry. Let them do that inquiry.
You decide the representation.
Yes.
And
ওদের ডেকে পাঠাও।
he is appearing on behalf of the private respondent.
Number 7, my lord.
My lord, I am appearing on behalf of the state, my lord, in this matter. Kindly allow me, my lord. Due to network problem, just it is getting late to appear, my lord. Kindly consider.
Yes, tell me. What do you have to say, Mr. Mandal?
Yes, my lord, I am appearing on behalf of the state, my lord. Due to
That is
network
a-
problem,
yes,
just it is not properly audible, my lord. Kindly, sorry, my lord, kindly once again.
Now, may I tell him? Sandeep,
Saying, what do you have to say, Mr. Mandal? Do you have to make
Yes, my lord. In this matter, my lord, the state has no role, my lord. Actually, my lord, whatever the direction, my lord, may be passed, the state authority is eager to comply the matter, my lord.
Yes.
Lord, I appear on behalf of the respondent number 7, private respondent, Lord. I deny all the allegations. There is a old structure, my lord. Let the municipality consider.
very well. Municipality will consider everything.
Take down. Learned counsel. Petitioner has challenged the petitioner has filed the present writ petition alleging unauthorized construction
আচ্ছা ঠিক আছে মিলে যাবে
on
তোমার বাড়ি ভাঙতে যাবে আর তোমার বাড়ির উপর নজর পড়ে গেছে।
what is the address?
I'm so sorry, Milord. I was asking something from
Address.
yes.
Unauthorized construction over
Page 43, Milord. Page 42, my lord will get the address, Milord. I'm so sorry. Kindly seize, Milord.
over
Milord, page 41, second paragraph. Moumita Bera, wife of so-and-so, near Sanghoshri Club, Post Office Goria, Police Station Narendra, Kolkata, has purchased the below scheduled land from so-and-so by, the schedule is there at page 42 and the construction is made on that. Dag number 3063, RS dag number, Khotiyan number 863.
Unauthorized construction
এখানেই তো হয়েছে।
on RS Dag number 3063 corresponding RS Ketan number 863 lying within Mauza, Barhans, Fartabad, comprised in jail number 47 within limits of ward number 29 of Rajpur, Sonarpur municipality. PS Narendrapur, Calcutta 70084, District South 24 Parganas. Counsel for the petitioner states that
Lords, kindly leave me. Another matter is, I'm praying to leave, Lords.
the directions are being passed. How can you leave? Counsel for the petitioner alleges that unauthorized construction is being carried out by one Srimati Momita Bera Ghosh. Respondent number. What is respondent number here?
No, respondent number 7.
Respondent number 7 in the presented petition. Full stop.
আমার লাগবে না, নিয়ে চলে যাওয়ার কি হবে?
Petitioner states that he had made a representation before the concerned municipal authority on 25/1/2025. Full stop. The same has not been acted upon, nor any action has been taken. Full stop. Learned counsel for the respondent, who appears for the municipality, Rajpur Sonarpur municipality, states that they are ready and willing to decide petitioner's representation dated 25/1/2025. Full stop. In view of the statement made by the learned counsel for the petitioner, for the respondent, the petitioner states that his grievances will be satisfied if the representation is decided in a time-bound manner. Full stop. In view of this court directs the respondent, Rajpur Sonarpur municipality, to decide petitioner's representation dated 25/1/2025 within a period of 8 weeks from the date of communication of this order, after affording an opportunity of personal hearing to the petitioner as well as the private respondents.
And take consequential steps. But in the event they find that there is illegal construction, otherwise again I have to come up.
Private respondent. That is something which is expected.
As your lordship. As your lordship.
Private respondents. With the above direction, the present writ petition is disposed.
Grateful to you.
Grateful, Mike. Item number 85.
I'm for the state, my lord.
ये एक मंगाना, ये मंगा देना, ये चाहिए, अभी अभी बोलो लेके आए, ये मंगवाना। Yes.
I'm for the stay in this matter.
Who's for the petitioner?
Allegation is unauthorized construction. They made a representation.
None appears for the petitioner. Even on the earlier occasion, i.e. 23/2025, there was no appearance on behalf of the petitioner. Full stop. It seems the petitioner is not interested in pursuing the present writ petition. The same is dismissed in default. These are the petitions which are filed to settle different. They file this petition. The owners get scared
Normally what happens?
and they don't appear.
Normally what happens, the person wallet are making a complaint. Now when the corporation issues a stop work notice, both the parties are trying to settle the matter. If settled, then wallet they will not come, and if not settled, they will come.
Not only settlement, extortion also.
In Howrah, your lordship will find more than 100 cases. When your lordship will take up the mixer, your lordship will find. The person residing in Hooghly, Purulia, they file a complaint that the Howrah unauthorized construction is going on.
Is there, are there some petitioners who have like filed 10 cases, 20 cases? You maintain records?
This type of particular, there are 2 or 3 persons, they used to file this type of petitions.
In any one of those cases, just point
When it is come, if you are have it.
Mr. Ghosh, we need to do
Knows
something.
better than us.
Obviously, Mr. Ghosh is sitting there smiling away.
Complaint করে না একজন লোক সেই একই যেমন হেসামুদ্দিন
Mr. Ghosh, we should do something. These extortion racket which is going on should be stopped.
In Narkeldanga area, Kolkata, your lordship will find where Mr. Ghosh is also appearing. Several cases.
Judiciary can stop it, my lord. Only judiciary can stop it because yes,
হেসামুদ্দিনটা বলে দাও না আসল জিনিসটা হেতেসামুদ্দিনটা one person হেতেসামুদ্দিন your lordship will find no at least my lord 7-8 already done নারকেলডাঙ্গা পুলিশ স্টেশনে বলো না already হয়েছে 2 FIR lodged ultimately bail granted everything now my lord what happened my lord, those person from whom he is asking for money they lodged a complaint before the police station a FIR has been lodged after sometimes he got the bail again filing the same petition easy.
We'll take your assistance, Mr. Ghosh, to do something about this. Next.
Item number 88.
Your Lordship, I'm praying for a short passover. Mr. Arindam Banerjee is engaged in court number 11. Kindly.
This is that matter, my lord.
I know.
Awesome. Mr. Banerjee is engaged in court number 11 in item number 17.
Any idea what are the instructions?
I have no idea.
None. Have it on Tuesday then.
But will your lordship be pleased to mark it as part heard? Your lordship has heard this matter substantially.
No, I've not heard it at all.
Well, Mr. Banner, it's just 4 days.
That is the view which I've expressed, but I have not heard it.
Wait at the top of the list.
Well, may I request
We still have to start.
Well, maybe request for an indulgence, my lord. If it can be at the top of the list, my lord, then at top of the list or to be mentioned
on Tuesday.
On tomorrow, my lord. Tomorrow has to be mentioned.
My lord, Mr. Banerjee is on his way to here.
So we'll wait, my lord.
You can tell me briefly.
Well, because in this matter, well, the 700 square meters, with which my learned friend is joining issue, my lord, he's saying that the right of that 700 square meter is with the building and the occupants of the building, which is 227 ADC Bose Road. My lord, series of litigations have been filed from 2002 onwards. Lastly, my lord, there were 3 writ petitions which were filed in 2015, which is in connection of sanction plan and separate assessment number. The same release which have been sought in this writ petition, identical release by the association. That was dismissed by the division bench. Also, my lord, division bench in that, well, I'll just read out one paragraph. Since my learned friend is not there, division bench holds very specifically, my lord, paragraph 65 of the judgment that
page 62. Page 62.
Let me just read it out.
So we are filing. Let's file it now.
Copy for it. It is found that there is not a single piece of document which shows HON'BLE Welfare Association or its members have any right, title, or interest or possession over the 700 square meter of land. It is straight law that if there is no legal right of the petitioner,
So this is one, my lord, where, my lord, in the writ petition, this was dismissed. Secondly, my lord, since your lordship asked me, that the petition that hearing.
We were just trying to understand.
Yes, yes, no.
Nothing else. No, no, you catch your breaths.
Catch your. I was in court number 11.
I understand. She told me that. Catch your breath.
My lord, I tried my best to convey as an officer of court. I may have failed your lordship on that.
Not a problem. Not an issue, Mr.
Please do not take me.
No, no, not at all. See, we can only make an effort. It's not in our hand. It's okay. So you can make your submission. But Mr. Banerjee, since your client was also a part of the association, he is well aware of whatever has happened. Why didn't you file those orders? You have only mentioned
The proceedings.
just one paragraph.
They ought to have been brought to the.
One paragraph.
Now the Supreme Court is clear. One has to bring not only plead, but bring to the notice of the Honorable Court anything which may have a bearing on the matter.
So complete suppression of
Lord,
complete suppression.
I would leave it to your lordship, Lord. Only one prayer I had. My instructions are, my lord, to renew the prayer which I had made on the earlier occasion is to, my lord, if your lordship so feels, if your lordship may permit the writ petition to be to stand over until, my lord, the review is heard out, because the review may have some bearing on the writ. Submissions are that the writ petition and the review, the causes of action of both are slightly different in that the letters that has been sent recently by my client has a separate angle, my lord, to canvass in respect of illegality of the plan, which is DHORS section 397, which is for suppression and material misrepresentation. 397 was by the association. 397 is now pending in review. The Honorable Single Judge did not make any order. The Honorable Division Bench did not consider the appeal and therefore passed a composite order without making any order on that writ. Apropos that, my lord, the matter was carried to the Supreme Court. There, my lord, liberty was given to file a review and then come back if the review is not addressed. Then, my lord, a review has been filed. That review has come up for consideration. There will be an overlap of the cause of action here and the review. My lord, I started that, my lord, with that submission, but there's a slight difference also in that it challenges the frustrum of the plan. My submission, which your lordship was prima facie not impressed with on the earlier occasion, was that a portion of the premises which is subsumed by an earlier plan cannot subsequently be hived off and made subject matter of a site for sanction. That, according to me, my lord, prevents the municipal authorities from considering the second plan, and that is a fundamental deficiency.
Those issues have already been dealt with.
My lords?
Those issues have already been dealt with in the earlier round of litigation.
Now, my lord, here the
my point is why
were the orders not made part of the litigation? Yes. I will not be standing here at the bar. I am not going to make too many issues about that. The orders ought to have been annexed to the writ petition.
So your client has no problem if I initiate proceedings and all.
I have spoken to them. I have told them the consequences. They are saying that
they are very pretty.
My lords.
They're very pretty sitting over all this.
The name suggests that they are pretty, but whether they are pretty, I leave it to your lordship, lord. I have done my bit trying to communicate.
No, we will hear this. I'll spend 2 days on it.
My lord.
I'll record everything. I'll get everything on record, and then I'll take it to a logical end. I'm in no hurry. I'll hear you out. Every contention of yours, I'll deal with it.
My lord, if my lords are so pleased, lord.
But one thing is for sure, that as an officer of the court, to agitate this with suppression of fact, at least you should withdraw this and file a writ petition with better particulars. At least this much.
This much we can do.
If you want to, no, I am not permitting you. You withdraw this. You have the liberty to file a proceeding in accordance with law. I'm not making any adverse remarks or anything.
If you, the only difficulty here would be, my lord knows that those line of judgments, when a writ petition is withdrawn, with
I will dictate
file proceedings.
I will say that liberty to file a petition with better particulars.
I will not make any further submission. I bow down to that.
Learned counsel,
Not make any further submission is one.
learned counsel, the petitioner seeks to withdraw the present writ petition with liberty to file a petition with better particulars.
All my
Well-
points are kept open.
My lord, all my points,
That's
on
it.
maintainability, all points.
That's
Anyways,
that's
Court, I am not
gone into the
deciding,
merit
not into the merit at all. Dismissal withdraw.
I'm grateful to your lordship.
Lord, shall we second?
Item number 98.
But I am for the writ petitioner. I am for the writ petition.
Hello.
But your lordship, kindly excuse me, I was not there on the last day when this matter was being called on. But in this case, Lord, I have been served with a notice under section 180 of the Howrah Municipal Corporation Act, wherein my building has been declared to be a dangerous building in a ruinous condition. Lord, the law, Lord, I shall cite before your lordship, Lord, 180 suggests that yes, if the commissioner is of the opinion that the building has an imminent danger to the locality and it is in such a ruinous condition, Lord, he can ask the occupier as well as the owner. In my case, I am the owner. Lord, declaring the building to be, Lord, dangerous one and directing the necessary steps to be taken. Now, Lord, I want that, Lord, apropos to the direction passed by the Howrah Municipal Corporation, thereby declaring my building to be dangerous, which is at page 43 of my lord's brief. If your lordship once looks at that notice, it's in Bengali, my lord. I shall try to read before your lordship.
Do you have tenants in this building?
Yes, my lord, I am coming to that. My lord, this portion, my lord, the holding number your lordship has got, my lord, 197/2.
Sir, you have tenants in this.
But I am coming, my lord. Tenant is on a separate part. I shall show before your lordship. If I can demonstrate before your lordship without touching them or without touching their possession, I can, my lord, demolish this portion wherein no tenant are residing. My lord, I can satisfy if
You will demolish it for the purposes of reconstruction.
For the purpose of reconstruction.
Reconstruction would mean that you are taking the entire land into DFAR.
No, not that. Even not that, my lord. My lord, there will be no foul play. I take, my lord, from your lordships, my lord, being an officer of the court, I shall try to demonstrate there is no foul play, my lord, on my part.
Make your argument.
My lord, if your lordship takes up, my lord, my writ petition, paragraph 3 once.
Paragraph 3.
As per your lordship's first query, whether you do have a tenant in respect of that premises, but kindly takes up paragraph 3. Your petitioner states that it is pertinent to mention here that your petitioner have already initiated one suit for eviction being title suit number 1329 of 2024, inter alia seeking for eviction of the private respondent in respect of a portion of the suit property at premises number 197/2, Netaji Subhash Road, such and such. Now, kindly see how it has been bounded, how it is described, butted and bounded. North, your lordship has got passage. Has your lordship got? On the south, passage with boundary wall. On the east, erstwhile tenant's property, that's different. On the west, landlord's occupied portion. I will just hand over to your lordship, the eviction suit plain. My lord, kindly tallies, the schedule from, as I have set out in paragraph 3 of my writ
When
petition.
you say on the east erstwhile tenant's property, is it a separate block?
It's a separate block. I have handed over to your lordship the eviction suit plain, where the schedule is there at the last page. Your lordship will get prior to the affidavit portion. Now, where is my possession, my lord? May I take your lordship first to page 18 of my lord's brief once your lordship takes up. Lord, I have shown before your lordship the eviction suit. My lord, it's pending. I have taken due course of law for eviction of my tenant. I don't want them eviction on a, my lord, other process. The eviction suit is pending. Now, if your lordship takes up page 18 once, this is another suit protecting my possession.
So that the tenant is Swapanjati.
Swapanjati.
Namita Singh.
Swapanjati, yes.
Savita Day,
Yes.
and Anita Dolia. Dolu.
Their occupied portion is being delineated, my lord. What is their occupied portion in respect of my property? And there is no dispute. Why? I will tell your lordship. Kindly, your lordship. I'm sorry. Excited হয়ে যাচ্ছে। আরেকটা কপি নেই না?
In the schedule which you are showing me,
My lord.
they are staying on the ground floor of the premises.
My lord.
Ground floor.
Ground floor.
She's on the ground floor.
She is on the ground floor, or separate portion, my lord, wherein, my lord, in the butted and bounded portion, I have shown before your lordship, the landlord occupied portion, mine occupied portion is being delineated on the west side. Now, my lord, may I take your lordship to in respect of my property? What is dilapidated? Kindly looks at page 18. Page 18 of my lord's brief. My lord, that is a different suit for eviction. This is a plaint of another suit instituted by me, title suit number 232 of 2020. Has your lordship got it? For declaration of my right title interest in respect of a separate portion of that premises wherein I am residing. If your lordship takes up the schedule at page 25 of my lord's brief, has your lordship got it? The entirety of the property is being described in schedule A. Has your lordship got it, my lord?
Yes.
Schedule B is the 3-story dilapidated building that I am talking about, wherein the notice has been served. That is schedule B, my occupied portion. I'm clear to your lordship, my lord. And if your lordship turns over the page, schedule C is his occupied portion. This 3 schedule has been, my lord, described, and what I have prayed for, if your lordship takes up paragraph, my lord, sorry, page 24, I prayed, kindly see prayer schedule, sorry, my lord, C, small c. Decree for, has your lordship got it, my lord? Decree for permanent injunction restraining the defendant, including his men and agent, that is my tenant, my lord, employees from making any disturbance and or interference with the plaintiff's peaceful possession and enjoyment over B schedule property, which is my property. Now the court has passed an order of injunction. If your lordship takes up once after the plaint, page 29 of my lord's brief. In this suit,
yes,
page 29 of my lord's brief once. In this suit, wherein three schedule has been prescribed, and I have prayed for injunction in respect of my occupied portion, schedule B, kindly see the learned trial judge initially passed an order of ad interim injunction. Defendants are hereby restrained from interfering with the peaceful possession of the plaintiff in respect of the B schedule property on the day that is such and such. So, my lord, B schedule property is that dilapidated 3-story building I have shown before your lordship, which is my occupied portion. Now, kindly, this is the, my lord, order of injunction that the private respondent are suffering before your lordship, my lord, I have shown. If your lordship turns over the page,
yes,
my lord, page 30, your lordship kindly takes up once thereafter. 30, sir, 30. 30. 30, your lordship is page 30, your lordship will get there is a disturbance on their part, on the part of my tenant, in disturbing my B schedule property. The direction was passed by the learned trial judge to implement that order to police help. So prima facie, my right title interest in respect of that property was not established. Page 33, kindly once looks at page 33, that order of injunction has been confirmed on contested hearing till the disposal of the suit. Page 33. Page 34, operating portion, your lordship will get. Accordingly, it is hereby ordered that the defendant is restrained from disturbing the plaintiff's peaceful possession and enjoyment of the B schedule property in any manner whatsoever. This is till disposal of the suit. So temporary injunction application got disposed of on merit. They preferred an appeal, my lord. If your lordship takes up, my lord, page 35, they preferred a miscellaneous appeal before the appellate court, and their appeal got dismissed on merit. Page 41 is the operating portion. So this B schedule property, my lord, I am the landlord. My lord, I do admire that there is a portion of the premises let out to him. That has no nexus with the occupied portion of 3-story dilapidated building of mine. Rather, there is a suit filed by me wherein my right title interest in respect of the B schedule property established, injunction order is subsisting, restraining them from making any disturbance in respect of my 3-story building occupation, and that order of injunction got confirmed. They preferred an appeal, that appeal got dismissed. In the meantime, what I suffered, what is my apprehension, your lordship kindly consider. Today your lordship knows there are many buildings are in a dangerous condition. If today this building of mine is collapsed, I being the owner, I will be the person responsible who have not carried out. Since this page 43 is a notice, if your lordship takes up, the commissioner, the Howrah Corporation, Howrah Municipal Corporation itself found my building is in a dilapidated condition. In Bengali, it's written Bhogno Pray Badi. It's in totally ruinous condition according to them. What I propose is, I do not want to disturb his occupation in respect of the other portion for which eviction suit is pending. My possession in respect of 3-story building is being protected. I want this dilapidated building to be demolished so that no untoward incident happen. It's not a case, your lordship can be apprehended that yes, it is such a case that the landlord to get rid of his tenant wants to demolish so that the tenant can be evicted. It is not such a case before your lordship, because I have taken a due course of law for eviction of my tenant. Eviction suit is pending. I have shown before your lordship my possession in respect of that dilapidated 3-story building is not being disturbed by the learned trial judge. Rather, the learned trial judge prima facie observed that yes, I do have right title interest, and the defendant being a tenant don't have any right to disturb my possession in respect of that B schedule property. Thereafter, this notice, after this page 43, if your lordship takes up page 44 onwards, I have written many times to the Howrah Municipal Corporation, kindly decide something. You have declared yourself that yes, building is a dangerous condition. Tomorrow, if it is collapsed and some of the neighbor got injured or some untoward incident happen, I will be the person who will held responsible for this. I am the owner. The Howrah Municipal Corporation cannot be said to agitate one issue and left it not to be decided thereafter. Because in future, if something happened, the Howrah Municipal Corporation will say, I have already served you a notice. Apropos to the notice, you have not done anything. And it is a special case, my lord, where no objection in respect of the tenants are not required because he is not occupying that. He lost, my lord, up to the miscellaneous appellate court to show that he do have any interest in respect of that 3-story building. He is suffering an order of injunction, and that order of injunction being challenged by them not get successful before the appellate court. So in such a case, the corporation cannot say, I believe my junior was there, a submission was being made that until and unless no objection is being issued, this tenant, this notorious tenant will never give me no objection, because he wants everything to be enjoyed by him. But his tenancy is restricted to that portion. He has suffered an order before the trial court up to the miscellaneous appellate court that he don't have any interest in respect of this 3-story dilapidated building, which is described as B schedule property. So it's I being the owner, upon being notice served by the municipality, I want that dilapidated building to be, my lord, demolished at my own cost.
Yes.
Grateful.
Well, I was a private respondent, the actual sufferer by my learned friend's lead petitioner. I will start.
That day you already argued your matter.
My lord,
That day you made your submission.
we are the tenant here.
Yes,
in
you
the-
already made your submission.
occupying the building, which is stated to be a in dangerous condition.
Mr. Banerjee, he has already made his submission that day.
But I'm,
He has given all brief about Constitution 21.
Madam, firstly, madam, may I submit? Sir, একটু বসুন স্যার।
আচ্ছা, না, ওইটা বলো যে during pending.
আরে আমাকে বলছি।
বলো।
He said it. Yes.
Firstly, madam, it was a title suit
No,
pending.
let him speak. Okay, say. What do you have to say?
স্যার বলছে আমাকে।
আচ্ছা, ঠিক। During pendency of the case, my lord,
Yes.
Howrah Municipal Corporation
Yes.
has given a notice of hearing dated 11/3/2025. But except my client, nobody had attended. The allegation is that the petitioner did not attend the hearing notice during pendency of this particular case. I'll kindly hand over the notice wherein only I have been there. Copy তোমরা পেয়েছো তো?
আমি তো অ্যাটেন্ডই করি।
তোমরা copy পেয়েছো? But except my client, nobody has appeared. During pendency of the writ petition.
I was never served.
I had been there and given my hazrana.
Yes.
Now, my lord, there are from the very beginning of purchase in the dalil in the document for purchase, they have stated for the very initially for the development and building, rebuilding, I am purchasing that particular property. From the very beginning, from building and rebuilding, I am purchasing this property. That was the statement in the document. From the very beginning. Now, my lord, in the meantime, Howrah becomes the oldest town of West Bengal. Howrah is 500 years. Job Charnock had started his business from B College, then Salt Lake, go down and Salkia, and thereafter from Calcutta. 500 years. And Charles Sadagar used Saraswati Nodi. Ganges was not so well for navigable purpose. That was the Saraswati Nodi. Now HIT Road, 150 feet away, HIT Road. English, French, Portugal has started their business through that particular channel. But Howrah is nowadays all the developers from all all parts of India have assembled here. Even Supreme Court judgment they are not obeying. Supreme Court in Patna case has stated that from the river side,
Sir,
1 kilometer, 1 minute, my lord, 1 kilometer would be remain vacant and not for multi-state building. That is in Patna case. Anyway, my lord, I'm coming to my own case. My lord, they have started 3 civil cases. First case has dismissed. My learned friend, the other plaintiff, first case has dismissed. Second 2 cases has pending for disposal. Now the third case, which my learned friend has just mentioned, that even the misappeal, again the rejection of the interim order may be done, by the willful, willful decision of the learned judge, nobody different. Against that particular judgment of appeal court, they are, my lord, coming to the High Court under 227. Because, my lord, entire building, entire first floor building is under my occupation. Is under my occupation.
All right.
Now, question the dilapidated portion.
All right, sir.
My lord, can I speak?
Mr. Bhattacharya.
Law point, my lord, I'll come. But fact is very important here. Fact is very important. Because dilapidation. And the dilapidation condition is that from the very beginning of purchase, they have not maintained the house. From the very beginning. From the very beginning of the purchase, they have not maintained the house. For what reason? Because, my lord, if they maintain the house, then it will not broken. Corporation will not sanction the front. Therefore, my lord, there, my lord, some beetle, some waste has been.
All right. Yes, Mr.
Therefore, no, I agree. My lord, 1 minute, my lord. 1 minute. I admit, I admit, my lord. I admit, my lord, 1 minute, my lord. Because, my lord, it is just, my lord, suit for eviction in disguise way.
I understood.
In disguise way.
Yes.
Therefore, my lord, the suit is not, the petition may not be maintained. My lord.
Yes.
Page 43, what they are relying upon. They are relying that we have found that it is a dangerous thing, but that is not the fact. We have called them for a hearing. They want a decision to be passed by us. So far as I can find, my lord.
So you give them a hearing.
I can, and only one thing, my lord, that they have, my brother has only argued, my lord, learned brother argued that there is a temporary injunction that is in favor of them. For that reason, they can do it, they can demolish it, they can renew it. But fact is that the title suit is pending.
Title suit is pending. They can do. They can do nothing. You decided.
In their property also, and in that property also, it is a tenanted.
You already gave a hearing on 1st of
I have given a
1st
hearing,
of October.
but I am only praying for your lordship that a further hearing I can give, if your lordship desires. But so far as the renewal clause is there, I can only show the law point, my lord. The renewal clause is there, is at section 175C, my lord, clause 3.
This is Calcutta.
How municipal corporation? Without.
175.
$175.
175C. Clause 3, man.
Where
They are saying that renewal of building plan they have prayed for, that is pending. But fact is that if, because the suit is pending there, they says that already due to suit, they cannot renew it from 2020. So if the person as aforesaid lawfully claiming under him does not commence the erection of the building or the execution of a work within 2 years of the date on which the erection of the building or the execution of work is sanctioned, he shall give a notice under section 174. That is required, my lord. Let them, let them show that they have given notice, So far as their representation here at page 48 for renewal of building plan, that goes. Unless they can show the notice under section 174, such person shall before commencing the erection of the building or the execution of work within period to also give notice to the commissioner.
The petitioner has preferred the present date petition.
May I? What the timing, may I?
Just one fact. If your junior knows something,
I'm
just one fact.
Content is there.
Just one.
In any manner.
Just one. Just one. Just bear with me. क्या लिखा है? The present writ petition aggrieved by the inaction on part of the respondent municipality in not granting him the necessary permission for demolition of his premises, having ID number 172/2, Netaji Subhash Road, Police Station, Bantra, District, Howrah. Full stop. It is the case of the petitioner that he is the absolute owner of the premises in question. Full stop. Private respondents are in occupation of one part of the said premises, and hence title suit number 1329 of 2024 was initiated by the petitioner for their eviction, and which is still pending. And the same is still pending. Full stop. Further, due to disturbance caused by the private respondent in the peaceful enjoyment of the said property by the petitioner, title suit number 232/2020 was filed, and the same is still pending between the parties. Full stop. Since the property in question is in a dilapidated condition, the petitioner wanted to demolish the existing structure and reconstruct the same. Full stop. The respondent corporation had held a hearing on 1/10/2024, but
no decision was taken.
But no decision was taken. Learned counsel for the respondent corporation fairly submits that another hearing can be granted to the petitioner, wherein he can agitate all his grievances, and both the parties, petitioner as well as the private respondent, wherein both the parties can ventilate all their grievances, and a decision shall be taken after granting after hearing both the parties within a period of 4 weeks
On the date of communication.
from the date of communication of this order.
Representation. Representation.
Anything else?
Representation to be
With
Presentation is always there, but so far as the
after hearing the parties, and
provisions are there,
and
we
a
cannot-
speaking order shall be passed by the respondent corporation. Full stop. Needless to mention, the petitioner shall be at liberty to challenge the same in accordance with law.
Because my lord,
With the above direction, the presented petition is disposed of.
my lord has not mentioned about the renewal clause, renewal portion. If my lord will
They
not-
will hear everything, they will decide.
My lord.
My lord, hearing to both the sides, all the sides.
Both the, yes.
Keep your plan. You can. ওইটা নেই তো ওইটা থাকুক না পরে নেবো এখন ওই লাগবে না রেখে দাও না এই তো আছে তো ঠিক আছে
Number 101.
But I'm for the
I'm appealing for the Kolkata Municipal Corporation.
but I'm for the petitioner.
Your Lordship, at the face of this petition, it's not maintainable.
It's always good to see faces from the criminal bar. Yes.
Your Lordship kindly comes to the ground.
Petitioner case টাকা বলতে পারেন?
His petition letter.
But I'm for the petitioner. May I start then? But the mother of the petitioner, Rabia Khatun, was the owner in respect of premises number 55/JD Tiljola Road under Kolkata Municipal Corporation. My name of the Rabia Khatun was recorded in the corporation municipal records. But I have annexed page 13, 14, 15, 16. My lord. Name is recorded. Name was recorded Rabia Khatun in the municipal records. My lord. The said Rabia Khatun died in the year 2023. But I have annexed death certificate, page 11. And Rabia Khatun had 5 daughters and 2 sons. And one supplementary affidavit, I'm praying leave to file supplementary affidavit annexing the legal layers. May I file? But I have handed over all the parties.
PMC के कभी
But thereafter, my lord, suddenly, page 12 in the municipal records, one name of one daughter is appearing as the owner, Raisa Malik. Page 12, my lord, as your lordship got it.
Maybe it is respondent number 5.
Respondent number 5. His name was recorded as owner. But the Rabia Khatun had 5 daughters, 2 sons. And my lord, the municipal, Kolkata Municipal Act provides section 178, subsection 2, subrule 2. And may I place, my lord? All lands or buildings, to the extent these are contiguous or are within the same cartilage or are on the same foundation and are owned by the same owner or co-owners, but we are the co-owners of an undivided property, shall be treated as one unit for the purpose of assessment under this act. But thereafter, provided that if such land or building is subdivided into separate shares, which are not entirely independent and capable of separate enjoyment, the municipal commissioner, on application from the owners or co-owners, may apportion the valuation and assessment among the co-owners according to the value of their respective shares, treating the entire land or building as a single unit. Madam, may I please it, madam? The petitioner made representation to the municipal commissioner. Madam, page 17. But through his learned advocate, that representation has not been considered, my lord. But may I hand over, my lord?
Yes. May I please? Lordship,
You are the private respondent.
I'm for the private respondent.
I am for the Kolkata Municipal Corporation. I have obtained the municipal records. On what basis the name has been recorded, Lordship?
Lordship,
Ms. Gupta, what, how,
Lordship, before
Lordship, I have flagged the documents.
during my learned sister, Lordship kindly comes to the ground. Number 6. And prayer number D, your lordship. Ground number 6 and prayer number D. Rabia Khatun died back in 2003, your lordship, and they are praying to incorporate her name once again. This is the prayer.
no. Prayer is pass order directing
But
respondent.
name of legal heir. My lord, get.
Absolutely, your lordship.
No, that's
Whether they are entitled to do that.
I understand. This para 6 makes sense. What you're trying to say.
Yes, your lordship.
You're trying to say that this particular daughter had been given no objection or something of that sort by all the other
Yes, your lordship.
sisters. But para D is entirely different. Yes.
Lordship, the respondent number 5 is applied before the respondent authorities by virtue of an affidavit filed by her that she is the only legal heir, annexing the original death certificate of the petitioner. Rabia Khatun. On that basis, I flagged the documents, Lordship.
But that's a false statement.
Let's.
You take action as per. You decide the representation then.
Lordship.
I think that will be better. You decide the representation.
Good.
Let them make a fresh representation because.
Fresh representation for what?
Annexing the legal heir certificate which they have given by way of a supplementary affidavit, I believe.
The prayer itself is in bad law. The prayer is contrary to the pleading, your lordship.
God.
Okay.
Take down. The petitioner has preferred the presented petition seeking cancellation of mutation in favor of respondent number 5. for premises number 55/ZE, Tiljala Road, Calcutta. Learned counsel for the petitioner states that petitioner's mother, Rabia Khatun, had demised on 9/1/2003. Full stop. At the time of her death, she was survived by how many siblings survived by?
But 5 daughters, 2 sons.
She was survived by 5 daughters and 2 sons.
Document nahi.
Full stop.
Petitioner recorded item 48.
Petitioner has filed an additional affidavit which is taken on record, and a copy of the same has been handed over to the respondents, wherein petitioner what is this?
Annex the legally a certificate. with
Legally a
this petition.
certificate, magisterial certificate.
This is a statement, right? No
It's not a certificate, it's a affidavit has been annexed with this petition.
Magisterial affidavit, annexing.
The petitioner has put an affidavit of all the surviving legal heirs of Rabia Khatun. Full stop.
But only 2 have been made the parties, Your Lordship. Other have not been made parties to the rate yet, Your Lordship.
Learned counsel for the respondent number 5 states that the petitioner has not impleaded all the legal heirs of Rabia Khatun in the present proceedings. Full stop. He has only made respond number
2.
Only 5, Your Lordship.
2 daughters has come before Your Lordship.
Only 2 daughters has come.
Petitioner.
There are 6 legal heirs in total, Your Lordship.
2 daughters
7.
have come.
7.
Yes.
Has not impleaded all the other legal heirs. Full stop. Ms. Pyali Sengupta. Gupta. Ms. Pyali Sengupta, who appears for the Calcutta Municipal Corporation, states that the mutation has been effected on the basis of an affidavit sworn by respondent number 5, wherein she has declared her to be the sole surviving legal heir. On the basis of said affidavit, the respondent corporation has mutated the property premises number 55/ZE, Tiljala Road, Calcutta, in her favor in the municipal records. Full stop. She states that the learned counsel for the, she states that the petitioner shall submit a representation. Though the petitioner has made a representation dated 22/1/2025 before the respondent corporation, but the same is bereft of material particulars, wherein all the legal heirs are not mentioned. Full stop. This court grants liberty to the petitioner to make a fresh representation before the respondent municipal corporation within a period of 2 weeks from the date of communication of this order, from the date of passing of this order. Full stop. If such representation is made within the time prescribed, the respondent corporation shall decide the said representation within 4 weeks from the date of filing of the representation, after affording an opportunity of personal hearing to the petitioner as well as all the respondents all the respondents slash legal heirs of Rabia Khatun. Full stop. Needless to state, a speaking order shall be passed thereafter within a period of 2 weeks. Full stop. With the above direction, the present writ petition is disposed.
Grateful, my lord.
Only one respondent was made, one of the legal heirs was made despondent. Kindly, Your Lordship, specify that.
He has
all the-
stated the legal heirs. It is stated in the order.
All legal.
It is stated in the order.
Stated, that's why I stated. All legal.
Not affidavit of service, my lord. May I?
Affidavit of service is taken up.
Item number 110.
My lord, in this matter, I am for the petitioner, my lord. 110. Oh, sorry. No, my lord. 101 or 110, my lord. 110, my lord, I am for the petitioner, my lord. Lord, am I audible?
Yes, you are.
Yes, my lord, the service is not yet been ready, my lord. Therefore, I am praying for 1 week adjournment in this matter.
What is not ready?
Service. Not service, affidavit of service.
Not.
Item number 111.
I am appearing on behalf of the respondent, my lord.
My lord, I am on behalf of the petitioner, lordship. But the
You
petition.
appear for state, I think.
No, I am
The
appearing
corporation
on
of
municipal.
Balika.
Led by
Parliament.
Mr. Owen Banerjee.
My lord, the grievance of the petitioner is that he had prayed for an adjournment on one occasion when a hearing was going on. Lordship, without granting him that opportunity of adjournment, Lordship, a final order of self-demolition has been passed. Lordship, challenging that and primarily on the ground of natural justice, Lordship, we are before you.
Final review.
My lord, in this matter, my submission is that they
I
are
filed a review.
My lord, this is before.
provision for appeal, my lord, before the civil court.
Civil court.
There is a provision of appeal, I bow down. But if I go there, Lordship, the difficulty is I miss out on a forum. Because it is not that I had not participated. On the previous 2 occasions, I had participated. Thereafter, on the next date fix, I had written to them of my personal difficulty that my marriage was there. There were several other difficulties due to which I will not be able to appear on that day. Lordship, if kindly
That
takes.
is no ground, sir. That is no ground.
Lordship, my junior friend had placed an order passed by a coordinate bench of this court, Lordship, where it has been, Lordship, where under similar circumstances, Lordship, an order was set aside and the petitioner was given an opportunity of contesting before the hearing. Lordship, all that I pray for, Lordship, is that, my lord, may I be given just one opportunity, because, Lordship, I have been representing my case all along. It is just on one date that I missed. And on that particular date, Lordship, this demolition order has been passed. What my learned friend has said, Lordship, and what has fallen from your Lordship, I also bow down to that although there is a provision of appeal, but Lordship, understand in demolition cases, if I lose out on a forum, Lordship, that becomes very onerous on the petitioner. And also, Lordship, one more thing with your Lordship's kind indulgence, I need to point out. Lordship, the illegal construction is supposedly coming up at Lilua in Howrah. A person from Kolkata has gone there and, Lordship, without any locus, Lordship, he has filed a complaint.
But it is identified that there is a deviation, my lord.
I bow down, but Lordship, I had also previously written to them, that is my annexure P5 at page 27, where I had taken up the issue with persons who were particularly knowledgeable in this subject matter. I was preparing a report, Lordship. This is on 27th of September. The next date was on the 22nd of October. Lordship, on that date, I could not appear, and Lordship, I had made a representation which was duly acknowledged, Lordship, on that date, but the order has been passed ex parte.
Challenge the order, sir.
Lordship, the only difficulty, Lordship, as I am very humbly beseeching before my lords, is that in these cases, Lordship, losing out on a forum becomes very
this is-
onerous.
Over here, the case which you're citing is entirely on a different footing altogether. The respondent number 8, who was the alleged perpetrator, he sought an adjournment, the petitioner sought an adjournment, there was a inspection which was carried out.
Lordship,
Report was
similar.
not there.
I personally myself had appeared for
what-
respondent number 8 in that matter, Lordship. In
That's
this,
what I'm saying. They're entirely different. The facts of
But-
the case are entirely.
but here also, Lordship, I had prayed for an adjournment on a day, it was not given to me.
Take it in appeal, sir. I can dismiss it or you take it in appeal. If I dismiss it, you will lose few more forums.
I understand.
Then no relief will come to you.
Or Lordship may dispose it of with liberty given to the petitioner to approach the appellate forum.
That liberty is always there with you.
As per law, they have the liberty. And there is a time frame. No time frame. There is no time frame.
The liberty is always there. Learned counsel, the petitioner seeks to withdraw the present petition with liberty to file appropriate proceedings in accordance with law.
I'm clear. Yes, Lordship, my affidavit of service.
Affidavit of service is taken on record.
Item number 122.
122.
122, Lordship, I am for the petitioner. Lordship, I had heard this matter yesterday. Only few points, Lordship, I would like to point out. I am appearing with the private respondent. Lordship, if Lordship will kindly see page number 90.
This is that the erstwhile.
Yes. Lordship will
Very interesting, Mr. Bandit.
Lordship will kindly note one thing. Lordship will kindly see the first plan. The first plan which was issued.
Lordship, before my learned friend
2016.
submits, I am praying for accommodation, Lordship, because I have to take instructions from my client. When the building was completed or not, he is out of station.
You have nothing to do. He is here.
He is returning just on Saturday.
He is here. The answering respondent. Your performer respondent. Yes.
Lordship, may I only just, Lordship, yesterday only one clarification. Lordship was, the word which was used yesterday was extension. Actually, there is no extension. The G+3 plan, which was issued in 2015-16, expired in 2021.
Plan was issued in?
The plan was issued on 1/10/16. The first plan, which is G+3, which Lordship will kindly note that this plan is in the name of one Mr. Mahesh Kumar Tekdiwal, who is my vendor, the erstwhile owner, not in my name or the name of the respondents.
That's all right, sir. That
Then
doesn't matter.
this plan has expired on 3/10/2021. Now, if Lordship will kindly take page number 91, that is the plan annexed here with. That plan very specifically says, if Lordship will see the backside of the plan, non-commencement or erection, re-erection within 2 years will require fresh application for sanction.
All right. This is the plan of
2016.
Mr. Banerjee is here.
Your Lordship has seen, my lord, the pre-election plan. Initially, my lord, the plan, they have to commence within 2 years. Now, this, my lord, plan was sanctioned in 2016. 2 years, 18, there's no scope for him to commence the construction as per this plan.
Yes.
Next, my lord, kindly comes to the next plan, my lord, which is a modification plan.
Yes.
This is not at page 97, 91, 98. 98, man.
Yes.
This Lordship is the backside, my lord. This is, my lord, for additional floors only. Not for the original, not G+3. Kindly see, my lord. Just below, my lord, the stamp of Howrah Municipal
Yes.
Corporation.
Plan nahi.
Yes.
This is not dated 5th of December 2018. This is for
Plan annex করনি আমাদেরকে।
additional 4th and 5th floor. If your Lordship sees not the backside. Additional 4th and 5th floor over sanctioned G+3 building. So it has to be not above the G+3 building. On that date, date of sanction, there was no G+3 building. It was not given on November 18. On that date also, the developer was not in the picture. He came in 2023. So, both the plans relate to a period when he was not in the picture. Initially, 2 years expired. There was no G+3 building. So, this additional plan also cannot be used by him because the G+3 was not there. This is only for the 4th and 5th. So, on vacuum, we cannot construct. There was no plan for ground to 3rd floor on that date when he started the construction. So, this is regarding the plans. So, admittedly, there was no plan. He has admitted on the last day that today there is no plan. Now, the provisions also say that he will have to apply for a plan and construct. Whoever intends to construct. If a lordship sees 173 and 174 the person who intends to construct has to make an application showing his intention to construct and then raise the building. 173 and 174. There is no such application by him, cannot be. Yes. So, first point is that the plan he could not have utilized because it had expired within two years. Fresh application formula was to be filed, which was not filed. It expired.
The first plan was 2016.
16. It was
expired in 21, right?
21. But the plan says that if you don't commence construction within 2 years, then you have to make a fresh application. There was no construction because the developer, he is not the person. He came in picture in 2023. So within 18, yes.
Not the law.
Yes.
If you do not complete it within 2 years, then you have to make an application.
Application, yes.
That is at 175C3.
So nobody has made any application,
I don't know. I have to file an affidavit regarding this one. Whether what time they are done.
Because the development agreement is of 19th January 2023. 7 years after this plan, G+3 plan. So before that, the developer was not in existence. Before 19th of January 2023. So he could not have made the application within 2 years.
The private respondent can
2 years from the no, how can they say? Because he was not in the picture. 1st October 16, 2 years. 1st October 2018. That is the period within which construction was to commence. After that, fresh application.
In that case, I have
that plan goes. Because no construction was made at that point of time. Then, my lord, the subsequent plan is only for 4th and 5th. I've shown your lordship, page 97, only 4th and 5th over the G+3. If G+3 is not there, how can he get 4th and 5th? Third point is, there are lateral deviations. The areas, surrounding areas have been encroached, which is in deviation of even these plans, non-existent plans, previous plans. So there is not violation also.
So if the
Statutory
violations are concerned, we can make an inspection regarding that.
Let them file the report, but in the meantime, let them not induct third parties, because what happens everywhere, during this process, third parties are inducted. They will not then file application, say we are interested party, we have been inducted. Let them not induct somebody, let them not.
So in that case, I have to take instructions whether there was a G+3 structure on that particular date when the plan was for 4 and 5 was sanctioned or not. It is also
because the development agreement does not say, it is apparent of the development agreement. It says that I am giving him a land, he will have to make a construction. So on 19th of January 23, there was no building, G+3 building. The development agreement is annexed to the writ petition.
Building was
page
constructed
41.
Within 2023. And now they have come before the court. And it is actually a dispute between the parties, the landlord and development regarding their allocation.
He can violate the law and make construction.
And I have done it on behalf of the landlord.
The petitioner is aggrieved by inaction on part of the respondent municipality in not taking any action against the unauthorized construction in the form of G+5 floors being carried out at holding number 289 Netaji Subhash Road, Post Office Havra, Police Station Shibpur, District Havra, without obtaining any valid sanction plan. It is the case of the petitioner that he is the absolute owner of the premises in question, while registered sale deed dated 30/11/2022, full stop. The petitioner entered into a development agreement dated 19/1/2023 with the private respond number 527 for the development of the said premises, full stop. However, contrary to the specific instructions given by the petitioner, the private respondents raised a multi-storied building with 6 floors over the said property without obtaining the sanctioned building plan from the respondent municipality. Full stop. The petitioner had filed various complaints with the respondent authority. However, no action has been taken. Full stop. Learned counsel for the respondent municipality states that he shall be filing his affidavit in opposition, shall conduct an inspection and file a report within a period of 2 weeks. You're the junior? Within 2 weeks. Full stop. You will file something?
I will file also.
Affidavit in opposition within 3 weeks. Reply to the same within 1 week thereafter. Same respondents, including the private respondent, shall file affidavit in opposition within a period of 3 weeks. Reply to the same, if any, within 1 week thereafter. List after 4 weeks.
Let them not create third-party interest in the meantime, because that is the biggest problem we face, my lord. After your lordship finds,
I can't do that. I'm only looking into the
legality. Now, if the building is
Only
illegal, my lord, the corporation cannot issue occupancy certificate.
You have civil remedies available. See,
as per the act,
your
also,
dispute regarding the builder, you have remedies available. Take your development agreement to the court. I'm only
that dispute I am not before your lordship.
I'm only looking into the.
But not if there's illegality, if there's deviation,
I'm not gonna
occupancy certificate cannot be issued.
Obviously, it will not be issued.
Then if somebody is inducted
see
by
that.
violating that provision, that is also bad.
We will see that. Nobody will come. This will be
This is before your lordship.
Mr. Banerjee, this will be overstressed.
I'll much obliged.
Item number 128.
In the instant writ petition, I have challenged the action of the municipal authority for enhancing the valuation of the premises in question from 8,000 and odd to 1,62,000 and odd. My vendor, without here, there is a provision for appeal. So, since the valuation has been enhanced without serving any notice upon the owner of the premises in question, I filed this writ petition on the ground of principle of violation of natural justice. That plea I have taken. The page 33, my vendor, the filed a representation before the concerned authority for the exorbitant enhancement of the valuation and the prayed for the reassessment of the valuation of the premises in question. Now, that is not answered. So, in this writ petition, I am praying for the direction upon the concerned authority to reassess the building. I am the owner of the premises in question.
Assessment was done in whose favor?
The assessment in the name of my vendor. My vendor purchase.
See, there are two things which goes against you. One, you're not the assessee here. Assessee is Shyam Sundar. You are challenging the assessment which has been done earlier in the name of Shyam Sundar. Not entitled to challenge it. Second, go before the tribunal.
Kindly comes to the page.
You want an order? I'll give you an order of dismissal.
I purchase.
You purchase, you didn't purchase. I'm not concerned. Go before the tax tribunal.
Since
order is appealable.
Order is appealable.
Go before the appellate authority, sir. You don't want to go, I'll decide it.
Only one thing, that ground I have
I'll
taken.
give you two things. Don't worry. I'll give you two findings against you.
I have taken.
I'll give you two findings. You want those findings or you want to go before the authority concerned?
That appeal is there. Admittedly, appeal is there.
All right, take down.
Now, only one thing. That now
I'll give you two things. I told you. Two things. One finding that you don't have a locus. The assessment was in favor of Shyam Sundar. You have no locus. And second finding, this is not maintainable before this court. Go and file it before the tribunal.
Since I have a subsequent purchaser, malad the property devolves upon me, malad.
Go and argue this before the tribunal. You want an order right now, or you want to try your luck somewhere else?
Malad that is malad whatever I shall go, malad that is the provision of
No,
law.
up to you. You tell me
provision-
what you want.
Malad
I have expressed my mind. I can't be more candid about it, sir. What do you want? You want to withdraw this and go before the tribunal, or you want me to pass an order?
Malad I am not the advocate on record, malad the for withdrawal, malad I have to take instruction.
Who's the advocate on record? Seek instruction. We'll have it tomorrow. You come tomorrow. Otherwise, two findings against you.
Grateful.
Oh, I'll record because he has come all the way. Proxy counsel so and so appears and states that the main arguing counsel is not available today due to some personal difficulty. Let this matter be listed tomorrow.
কবে আসবে?
You seek instruction tomorrow, sir.
Yes, I have already taken instruction.
Those are the 2 points.
Yes,
Yes, yes, malad the appeal is there. Malad
purchased in January 2025.
25.
Assessment in the hand
15.
of the predecessor in interest,
Yes.
who has not challenged. My learned friend's case is a representation at page 33. For my satisfaction, your lordship sees page 33. An undated
दिखाना,
document.
File दिखा.
Page 33, your lordship looks at. It is an afterthought prepared subsequently after the purchase. Does your lordship see any seal from the Kolkata Municipal Corporation that this letter has been received? This has been manufactured. There is no such existence of this letter in the files of the corporation.
in all occasion, malad the receiving authority, malad in all times, malad did not put their.
These are all submission from the bar.
You should file FIRs in these cases. This is forgery. This Shyam Sundar's,
Yes.
this is complete
Signature.
forgery. Probably it doesn't even exist anymore.
Yes. He says that he is existing.
Is he alive? Shyam Sundar is alive.
Then malad I have to take instruction.
I'm
malad.
telling you, Shyam Sundar would have.
Anyway, my lord, this is not maintainable as it has
Not
fallen from your lordship.
Not maintainable. On both accounts, it's not maintainable.
Recorded owner is not traceable. देखिए, विनोदी recorded owner is not traceable.
Chikacha.
Attend 129.
2 pages, Milord, I will show, Milord. Milord,
State response.
Milord, 42 is the, Milord,
Mr. Basu, yes, corporation. Which corporation is this?
Kharda municipality, Milord. Milord, the
Havra.
municipality,
Havra, right?
Kharda, not 24 Parganas, Milord.
Who appears for that?
I do not know, Milord, but the state is possibly, Milord. I have also made, Milord, the inspector, police, Milord, party respondent, because, Milord, the 145 order, Milord, page 42, that clearly states, Milord, the demolition. Last,
Yes.
Milord,
yes,
page
he-
40.
he's with me.
Police reporter.
Milord,
See, Mr.
it says-
Basu, Mr.
yes.
Basu, the problem is, till the time the corporation is not here, the municipality,
Yes, correct.
it's difficult to pass an order.
Should I serve a notice, Milord?
Please, sir.
Yes, Milord, kindly
Affidavit,
direct.
you give the affidavit of service is taken on record, though there is no appearance.
As well as private respondent also.
Why, Milord? Why he is
By
interested?
private respondent, who are you?
He is
Who
state.
are you?
Why is
I am
espousing
state.
the cause?
Keep
But
quiet.
private respondent is
Keep quiet, sir.
illegal construction is good.
It's all right. None of your concern. Affidavit of service is taken on record. Learned counsel for the petitioner shall serve upon the respondent municipality. Respond number,
So number?
respond number 2,
Yes.
3, 4,
2 to 4,
2 to 4. Afresh.
deeply obliged.
Let this matter be listed next week. Wednesday, Thursday, when do you want?
Wednesday?
দেবো কেন? Report সামনে
Wednesday. Serve them, we'll
কালকে পাঠিয়ে দেবো, দাঁড়ান।
Oh, Milord, Monday, Tuesday, holiday.
Tuesday
Thursday.
also. That's
Yes,
for state. Okay,
state.
Thursday. Thursday we'll have it Thursday.
Thursday. Deeply obliged.
Thursday, 13th.
13th.
So 10:30 on Tuesday.
State government has declared holiday.
That's why I'm saying 10:30 for us.
Kindly pursue the Honorable Chief Justice, Milord.
I don't know, 1:30.
My lord, I beg to appear on behalf of the petitioner in this matter. Let the affidavit of service be kept with the record. The petitioner got superannuated as the PO, personal officer of Howrah Municipal Corporation.
From criminal side you come here.
My lord,
From the criminal side you have come here.
I do everything, my lord. Now here petitioner is not getting the retirement dues, including pensions, payment of gratuity, leave encashment.
Pension, what's
Pension I'm very sensitive.
But can I take, because the state government is also required because.
I know they are required, but
Then
then
the state government also is there.
state government is required, but you send the documents and DLB will process it and then
Only
send.
one thing, let me take some.
If they will,
আরে আপনারা যদি না করেন আমাকে বলতে দিন।
if they will send to that.
Yes, that is the.
That's what he's saying, madam.
That I am saying. But can I file a report or your lordship direct that I will?
No,
As your lordship.
You file a report.
File a report within 3 weeks. I will file it.
So 3 weeks would be a little bit.
No, see.
2 weeks.
Yeah, pension matters.
2 weeks.
Pension matters, you know.
Pension. I am also. I'm sorry, my lord. I cannot say it.
Absolutely.
DPPG is not party in this matter, my lord.
ওইগুলো দেখুন add করতে বলুন।
DPPG is
add
not
করুন।
authority.
DPPG is the main authority is the DPPG.
The director of pension and protection fund.
If it is, I will make them party. Lordship.
বলা উচিত ছিল।
Make them a party.
Control of finance is there. You have
Because
not sent the
DPPG
file.
is the main authority because only
They have not
filing or
forwarded the
report will not do.
file. I'll make them party by this time.
Let them add it by today, man.
At the outset, learned counsel, the petitioner states that he has not made DPT a party. Director, pension and provident fund. Little bit I also know, madam. Liberty is granted to the petitioner to add DPT as a party to the present proceeding, full stop.
না না ওদেরই ভালো হবে তো DPPG না
The
পারে
petitioner has preferred the present petition agreed by
জুনিয়র নিলে এরকমই হয়
non-release of retirement dues even
পাতি
after
করে
4 years
জুনিয়র
from the
এরকম
date
ড্রাফট
of
করবে
superannuation. Full stop. It is stated by the learned counsel of the petitioner that the petitioner had superannuated on 31/4/2021. Full stop. Despite submitting all the documents before the respondent authority,
আমার নামটা অঙ্কিতের নাম
till date,
সন্দীপন
no pension has been released. Full stop. Learned counsel for the respondent corporation as well as respondent DLB, director local bodies shall file. First you
DLB is
file.
the party.
DLB is not a.
DL not be.
You have not
But
made
I
it.
made them
DLB
party.
also a party.
DLB is not important required. In this case, I made the department as a party.
No, in this case, TLB and
But why DLB is required?
What retirement always make the
DPP,
necessary-
I will make
DLB is the required party.
But
my lord.
DLB possibly is not required.
Arey baba.
It
DPP
is.
the required.
No. DLB is required.
DLB.
Criminal bar.
I will make them. Lordship, now
All
DLB,
parts.
Lordship, this is approved. His service is approved already by DLB.
Just
That's why I did.
এটা তো
not.
DLB
Nabo Likhana shall make and
Director local body and
Director
the DPPG party.
respondent shall file report within 2 weeks. Respondent corporation shall file report within 2 weeks. You please forward it.
I will, madam. Not a single day I will.
Matter will
But
appear.
today itself they should add a party.
Yes,
I will
yes.
do it.
Do it right now. Shall make a party and serve upon the added respondent. वहीं पे पूरी डाल देना.
এটা তাড়াতাড়ি
Affidavit of service taken. Rest of the matters tomorrow.